I mentioned this matter on the ground that I challenge the marks. And I am entitled to have the 1 mark. Actually, it was not right. So therefore, when I qualified, I have not qualified to go for the further process. So I mentioned this matter.
What is the number? Number, serial number.
Serial number 2068.
Just check. If it is mentioned, then upgrade.
Yes.
If it is mentioned,
Yes.
it will be upgraded. If not, then no.
It is mentioned.
Hello, may I permitted to 1 minute for correction?
Day after tomorrow to tomorrow.
All right, day after tomorrow.
May I permitted to mention 2 matters for correction?
Give.
I may be permitted to mention a matter, a contempt matter, my lord. I'm praying for upgradation.
No.
My lord had.
No. Call the list, please.
But item 1, I appear. Well, this is my affidavit of service. But here, I am questioning the reasoned order, which has been passed by the District Inspector of Schools at page 48.
AOR has been served. 48. All right.
Without serving the AOR, I cannot move the petition.
Right.
Page 48.
6th of June 23.
Yes, my son, the delay I have mentioned, and I have annexed the document also. My son met with a bike accident.
Yes.
All the medical documents are there, starting from page 68. Now, it's a case where this is my third writ petition. I have come to this court challenging the inaction on the part of the respondents to grant me
Approval.
Approval has been done.
All right.
Your Lordship, kindly have a look to page 39.
All right, let the other side come.
Very well.
None appears on behalf of the respondents, despite service. Stop. The reasoned order dated 6th June 2023, passed by the District Inspector of Schools, Secondary Education, Kolkata, is impugned in the instant writ petition. Stop. The matter has to be decided upon exchange of affidavits. Stop. Let affidavit in opposition be prepared and circulated within a period of 6 weeks. Reply, if any, within a fortnight thereafter. List the matter immediately. List the matter for hearing immediately on completion of the aforesaid time period. 23 matter, you are coming in 26.
Very well.
Yes.
Item 2 for the petitioner led by Mr. Shuktipada Jana, praying for not today.
Why?
Because he is not coming due to medical emergency. So I have no knowledge about this matter. Lordship.
Not this week?
Not this week.
Today is Tuesday. Medical emergency, not this week. Shamne Moshe. All right.
My lord, observation is possibly wrong observation has incorporated. My lord, kindly see the paragraph number 2 of your lordship's order. It has been submitted. It is my submission. It is single teacher distance round, but subsequent observation is incorporated as a medical ground. If your lordship desire, my lord, I can come with an application. There is no issue. But your lordship directed to observe it as in terms of Rupak Dua, it will be disposed of.
This is not medical ground.
No, not. My lord, kindly see paragraph number 2. It was my submission.
Single teacher is all right.
Yes.
But then the medical ground will not be there.
No. It has categorized that CMO, BMO is CMO after conducting BMO is CMO, it will be, my lord. It will clearly, it is indicated it's a medical.
All right. Pradeep, the petitioner submits that the petitioner seeks transfer on the petitioner seeks general transfer. Stop. The order dated 16th February 2026 recorded that the petitioner seeks transfer on medical ground. Stop. Such is not the instant case. Stop. Accordingly, the order dated 16th February 2026 stands recalled. Stop. The recalled and fresh order is passed herein. Single teacher, Rupak Dua.
Great.
Right.
Extremely great.
Order is corrected.
Great.
Next.
I am for the petitioner, my lord. Correction, my lord. Few correction. 21st July 2012 wrongly, but rightly 21st August 2012, my lord. If you kindly annex last annex.
It is you who mentioned it 21st July.
21st July, my lord. Wrongly, when the type of the application is still. Leave is granted, my lord, kindly.
If you see with this much of volume, the court making a mistake is something. But you, if you make a mistake and wrong submission and that is recorded, I have your copy. It is recorded in your own handwriting. It is July. And now you say you made it wrong.
Okay, annex.
Is it possible for the court to look into the date of death? No matter can be taken up if you proceed in this way.
Kindly, my lord, apology, my lord. Annex the P3, my lord. Or last annex, my lord.
Yes, next. Yes.
But here, my lord, I am appearing for the respondent number
But
4 and 5.
that matter where, my lord, on 10th February, your lordship was
Is any
placed in-
correction required?
No. Correction, my lord. We have mentioned matter on 17th. It was appeared.
No, in the list it is mentioned correction. This is the reason I was.
My application
But I am
is
filing exception.
also listed, my lord.
Your application is listed, it will be taken up.
Well, what has happened? They filed an application for recalling against your lordship's order dated 10th February, whereby your lordship imposed costs of 10,000 upon the school authority. Twice, my lord, they failed to file the report, my lord, before your lordship's, my lord. And the recalling application has no ground at all. Recalling the
My lord, my application, I have to submit before lordship.
I have the
He is
copy.
submitting.
I have the copy. That's why I am submitting.
What time you are submitting?
Can one?
But the crux of the matter is that petitioner is not getting.
List, the matter is not there in the list also.
kindly
Can
take
is not
up my
appearing in the
matter.
list.
Can is there? Can is appearing.
Can is appearing. Oh, acha, ekdam
That is
smart.
appearing in the list, my lord.
Can
This is the application I have filed before lordship. Last
Kindly
occasion
take it
I
up.
was absent, my lord. I have been suffering from throat infection.
No, it's all right. You get well.
Your lordship
Kindly
made
take up
the
the
observation,
application.
the school authority have made represented by 5 advocates.
Yes.
That is not the case.
Nay, I can see names of 5 advocates.
If anybody is appearing with me, that name is given in a different books. They are associated with me.
What does this mean? They will not have any role in the matter.
My
If
lord,
this is the learning that you are spreading to your juniors, then I'm sorry to say.
my lord, report was not given by the school authority.
Let the school pay cost.
Teacher in charge was suffering
Secretary.
from secretary.
Yes,
and
yes.
teachers. That I have annexed the medical report.
All right.
My lord, kindly consider this, that your losses one day failure by my part, your losses imposed cost 10,000.
Yes.
But very unfortunate, my
And
lord.
it is the school. It is not an individual.
Year after year, the matter is pending before this court.
Yes. Will you please make submission on merits?
But I am submitting merits.
Yes, please submit. Where is the report?
Page 8, my lord.
Page 8 of what? Where is the report?
Report, my lord, answer. That is the and start to all this part.
Yes. What does the report say?
Report is the unapproved teachers working, that is contractual labor, contractor teachers, and the 11 approved teachers in the school, 11. And that unapproved teacher, school authority, some of the students have left the school. So that school authority is failing to pay the salary. My lord,
See, you have said in paragraph number 4 that the school is a de-getting school and the petitioners are not approved
Yes.
and working for gain on contract basis and getting their salary from the school fund. The roll strength of the school is 219. 219 students in the school.
yes,
For in class.
Monthly tuition fee.
class 8, 9, 10.
Only 8, 9, 10.
And then less.
Have you mentioned that in 8, 9, 10? You have mentioned the roll strength in the school.
That is I have annexed.
Page 5. Page
Your
Yes.
averment does not say so.
Secondary section I have mentioned.
That
Second.
presently the role strength of the said school in the secondary section
Yes.
is 219.
Yes.
And the monthly tuition fees of the school vary between rupees 950 to rupees 1100. Photocopies of the relevant records pertaining to such roll strength and tuition fees are annexed here too and collectively marked with the letter R1.
For secondary section 219 students. Environment is
Secondary section is 219.
Do you have students in the upper primary section?
Yes.
That is not controlling by this school authority.
Yeah.
That the
That I have not annexed because this.
that I have not annexed.
Secondary.
That is in the secondary section.
What is the position with the upper primary section?
That is not.
Then I have to take instruction.
Then another take two instructions for that.
Why? Why will you take
Also, I
that?
have considered the secondary.
Why?
Because this teacher is. in
Why?
secondary section.
Because this teacher is engaged in the secondary section.
Does the order restrict you to disclose information only with secondary and the upper primary?
No.
And 12 plus 5
Well,
to
kindly
12.
consider my exception.
That
was.
is
Plus 5 to 12.
5
I
to
accept.
12, my lord, kindly see this.
Page 6.
Page 6.
Plus 5 to 12. The strength and the tuition fees. Page 6. Plus strength of students.
Even my lord,
There are 11 unapproved teaching staff in the school who are working on contractual basis and their salaries are paid from the school exchequer. This 11 unapproved staff teaches only 219 students.
yes, my lord. All
What do you
are
mean to
left
say?
in School.
Approved teachers of the entire school.
And approved school teachers in the entire school. So, my lord, the somebody is
You have got
adopted-
219 students in
Yes.
the, and there are 11 teachers. 11 teachers for
throughout the school
209.
is 11 unapproved teachers.
Right. Now, when you speak about the teachers, you speak about the whole school. And when you speak about the students, you speak about only 2 classes. What is the stand of the school? I'm going to impose a heavy cost.
Because this
Petitioners.
You are definitely concealing information.
the secondary education is
The court is not concerned.
kindly see this. Malad, the teacher in charge, but your losses are taken into consideration in the order sheet that school authority represented 5 advocates. Malad, school authority even not coming, not taking any instruction from. But I want.
Do not, why are you defending? Why are you defending a client who is not?
But I want to release this because
This is a
I have
profession.
told this.
You are an independent professional. You have got the choice of choosing who you will defend and who you will not. If your client is not cooperating, don't appear.
With the prayer, but that cost may not be imposed on my ground because I was in.
It was not your ground. It was on the
What does she
school's
say
ground.
there?
It was on the school's
this-
ground.
Ask my junior that the school has 5 advocates have been engaged, and you are seeking time. But there is very unfortunate matter. I never think
Sir,
about this.
please, if you want to contest the matter, contest on merits. What you have got to say, if you say you will contest, fine. If you say you will leave the brief, it is up to you. Choice is yours. Now the court is going to pass its order. You make your submission, the court will pass order.
But kindly
consider my
the
exception.
application, the consideration of the application.
No, application will remain. I'll see what is to be done.
Cost will remain.
Cost will remain. For the time being, the cost will remain. And I'll see what is to be done.
Kindly consider by
That is
exception.
the writ petition is not maintainable.
Exception by the petitioner
The writ
to the
petition is the contract
report
of labor.
by the respondent number 4 and 5.
Yes.
Kindly come to paragraph 5.
Yes.
There are 13 approved teachers, 12 assistant teacher and 1 teacher TIC.
13 approved teachers.
Approved teachers. And now kindly come to
12 assistant teacher and 1 teacher in
But,
charge.
yes,
That means 13.
absolutely. And kindly come to paragraph 10. I will answer everything. Paragraph 10.
Paragraph 10.
Regarding
yes.
strength of the student strength.
Hmm.
I state that the school has no financial distress at all, and as because the school has 530 student strength up to secondary section.
Where are you? All right,
Paragraph 10.
state.
And now
Yes.
kindly come to annexure 6 once. Annexure 6. Page 6. Annexure E1. What
Yes.
fashion the school is going on. Kindly see the fee structure. Admission fees they are taking for class 1, 4,900 in the month of January. Now part payment on July to 2026. This is current. Now kindly come to the
Is
next
it
page.
the same school where you?
Yes,
were
yes,
teaching?
yes, yes. And we are not getting our salary since March 2023. Now kindly come to page 7.
Yes.
This is the fee structure.
Hmm.
Monthly fee structure of the standard of the classification of classes is there.
Yes.
And then kindly come to page 8.
Hmm.
Payment received, tuition fees.
The payment received fees and this is the debit.
Of certain words of the school. That shows, my lord, that the school is not school has no financial distress. Intentionally, they are depriving the petitioner from getting their salary.
Where is the state?
Yes, my lord, I have already submitted. Your lordship is pleased to direct to file show cause.
Your report is here.
Yes, my lord. Last
What does the report say? What does the report say? Did you get a copy of the report of the state?
Yes.
Yes, I
Kindly
got it.
come to paragraph 13. The strength
13.
is in terms of our paragraph 10. They certify the strength of the students.
Total enrollment is 530. Secondary and higher secondary. 256 in the normal section.
And now they are saying 18th approved teacher.
80 number of approved teachers are working in the normal section. Four.
Paragraph 49.
Yes.
There no further vacancy.
No, that is separate.
Oh.
No, further vacancy is different.
The status of the schools.
Yes, I want to see how the school is functioning.
The 7 I have already disputed.
Yes. Since when are you not getting your salary?
Since 2011, we are getting deficit salary. Our salary was 23,000. We got 12,000 around. Now, since April 2023, no salary has been.
No salary. Why are you working without?
We are serving the school.
Why? For what good reason? Without being paid?
Because my petition.
Yes, 59. Salary for 2021.
Kindly see the column 28 September 2023 date.
Salary for
September.
you
It is
getting in
but
September.
after 2 years. Now the last column 24th November 2023, the salary of January 2022. That fashion they are disbursing the amount.
If you are not getting your salary, you should leave the school and look for some other schools. My work in a
The age of the petitioner now 56, 56, 57 probably. And my repeated representation is there.
No, representation is all right. How does the school propose to disburse the salary of the petitioner? How many are there?
2.
Petitioners. You have made them work. Can you direct or extract work service from a person without paying?
Not at all. But my submission is that
Trying to disburse
that
their
we are
salary.
trying to disburse, but today my submission is this writ petition is not maintainable.
All right.
Because of that, your lordship must assess costs against the writ petition.
Yes.
That is my submission.
All right. What is the fee structure which has been annexed to the report? Page 6 of the report of the exception filed
By the petitioners.
to the report of the respondent numbers 4 and 5. 4,900. 4,250 admission fees.
Kindly see paragraph 4 once. Until unless paid.
Exception.
Yes.
Kindly see that names of the successful candidate will not be entered in the attendance register unless they pay the school fees. Tuition fees.
That is
For
the
1 month
notice
session
chart
fees.
for admission.
Yes. That
is
means
the
you are
amendment fee
collecting
notice.
this much of money from the students and now you say you need to pay the teacher and you are extracting services.
Can your lordship kindly see the report, page 6?
No, page 6. No.
Page 6 and then next page 8.
Yes, daily cash summary.
Daily cash amount. Daily summary.
Where is the money going? The money that you are collecting, where is the money going?
Yeah, that is the separate question.
Pay the teachers.
This petitioner is thinking so that on that point he or she not getting the money from the salary, then he may go to the other cases, file the other cases for corruption. And what is corruption is everywhere.
And so you will promote it. And that is the reason you will promote corruption.
That is the reason I am not answerable. I am not giving the answer, only giving the answer today before your lordships. Then I shall take the another instruction stating all these things to the teacher in charge and headmaster. There is no headmaster, the teacher in charge. If that be so, that is the case of corruption. But by filing this writ petition, he is thinking so.
You are collecting money from the students and not paying salary to the teachers.
What money I have collecting, I have annexed.
This is your document. This is a notice of your school. It is, do you deny that this is not a notice of your school? This is your school's document.
That is not collecting. On the basis of that notice, some students are not coming, some students left the school. So
This is
not some students are not
please
paying
come.
the fees. Not paying fees. In this way, school will not run ultimately in future.
A report. A report in the form of affidavit by the respondent numbers 4 and 5. And the exception thereto filed by the petitioner in court today be written with the records. Achha. Report, exception by the petitioners to the report of the DI filed in court is also written with the records. Show cause by the ADI. Is taken on record. An application has been filed by the school seeking recalling and / or modification of the order dated 10th February 2026 passed by the court.
Kindly consider paragraph number 12 of the application. Page 5. No ground.
No ground, then what is that? What are these paragraphs? No grounds. What are the annexures and what are the following?
In the application, the applicant has mentioned that The matter was taken up for consideration by the court on 9th February 20. You mentioned 9th. See your application. Paragraph numbers 3, paragraph numbers 4.
That is subsequently.
Typographical.
10th February.
On 9th February 2026. ওরা তো বলেছে taken up on 9th February 2026. আচ্ছা তার আগে লিখুন 19শে জানুয়ারি। 19শে জানুয়ারি। আচ্ছা এটার আগে একটু লিখুন that in paragraph number 2, 3 of the application, the applicant has mentioned that order was passed by the court on 19th of January 2026, directing the applicant to file a report in the form of affidavit. And the matter was thereafter taken up for consideration by the court on 9th February 2026. Stop. From the records of the instant case, no order on 9th February 2026 is found. Stop. The court passed order on 10th of February 2026. Stop. The applicant has stated in paragraph number 5 that the court was pleased to impose cost of rupees 10,000. Stop. The learned senior counsel representing the applicant was unable to attend the court due to medical exigency. Stop. The applicants did not appoint 5 learned advocates to represent the case, and they are the chamber junior counsels assisting the learned senior counsel of the applicants. Stop. From records, it appears that a report was directed to be filed by the school way back on 8th of December 2025. Stop.
December orderটা পাওয়া যাবে
8 December হবে না। না এটা হবে না, 8 December হবে না। Question disclosure number of applicants.
not directed to the file. আমাদের excited disclosure.
This is the dates report. 19th January, school. আচ্ছা 19th January, তারপর হচ্ছে 10th of February. The report also mentions, now the applicant has also mentioned that the respondent number 4 was suffering from health issues. And as soon as the said respondent recovered, He contacted his lawyer and handed over the report on 10th February 2026. For which the report could not be affirmed on 9th February 2026 when the writ petition was taken up for hearing. Stop.
May I take leave? Please.
The aforesaid submission in averment in paragraph 10 of the application appears to be absolutely incorrect as the court did not take up the matter for hearing on the 9th of February 2026 as mentioned in the said paragraph. Stop. As the application appears to be contrary to the record, contrary to the records. Accordingly, the said application cannot be allowed. Stop. The application stands dismissed. Stop. The matter is fixed for further hearing. Act a line. The learned advocate representing the school raises an issue with regard to the maintainability of the writ petition. Stop. The matter is fixed for hearing on 20th of March 2026. Yes, next.
20th of March. 20th of March. Order dated 16 February 2026, my lord. Paragraph 3 is, my lord, corrected, but my lord, paragraph number 2, it should be deleted. Because, my lord, order dated 6 February 2026, my lord, paragraph 8 is correct, my lord. DI is the, my lord, South 24 Pargana, not, my lord, North.
Barakpur falls within South 24 Parganas.
Right.
Yes. Barakpur is within South 24 Parganas.
My lord, District Inspector of Schools, AC, South 24 Parganas.
And the Treasury Officer Barakpur too?
Treasury Officer, my lord, North. My DI is, my lord, Alipur, my lord, South 24 Parganas. Kindly see the petition, my lord, to page 2, my lord.
At the top, you have mentioned district, not 24 Parganas.
Well, I thought, my lord, petitioner district is not 24 Parganas, but my lord, DI is the, my lord, South 24 Parganas, Alipur.
The PPO is issued by the Barakpur 2 Treasury.
Right. Thereafter, he should be changed, my lord. My lord, his representation, my lord, District Inspector of School, Secondary Education, South 24 Parganas, my lord. Kindly see the,
Where you all make a mistake, where what is correct, it is very difficult to understand. This is to be deleted. Paragraph number 2, delete. Yes.
Five Malad beg to appear for the respondent bank.
Yes.
I'm led by Mr. Shoptamsu Basu Malad. He's in virtual mode.
All right. All right.
In respect to respondent 5, Malad, I the borrower, Malad, I file appeal before the debt recovery time.
Section 17 application. Borrower is not a party. They have not made the borrower as party.
Who is the petitioner?
For the state, Malad.
Mr. Sahara is the petitioner.
What is your status?
Not I being the borrower.
Mr. Sahara, let them say.
We challenge the banking activities before the date.
Borrower is the person whose property we are selling.
Yes,
Whichever.
then who is the petitioner? How
You
is
are the
petitioner
mortgager.
involved?
My lord, a sale
Petitioner
notice
is
has
third
been
party.
issued
Is a
by the
totally
bank
civil
under section
dispute,
13
title dispute.
13
Title dispute.
13-2,
in respect of my property,
your property.
but never this property has been mortgaged.
Then who is the borrower?
His property has been mortgaged.
Are two
with the
different
pu-
properties?
Different property, Punjab National Bank. According to them, I have encroached their property. Accordingly,
Well,
our
did
entire
we-
property has been under sale notice. There are numbers of cases. Just 2 orders I shall place before your lordship.
But how can the read code go into all this
Sale
dispute?
notice, my lord, in respect of my property. Division bench
It's a
upheld.
title dispute, absolute title dispute.
Whether it is your property, whether it is
That has been
the
upheld by the
private
division bench. I shall show to your
property.
lordship. A demarcation map has been prepared. That has been went up to the division bench. Division bench says, unless this demarcation map is touched by any court of law, it is my property.
So go to the tribunal and get it done.
Yes.
I cannot. I am not a borrower.
May not be any person.
High
can
court-
do
No. I
Yes.
see, my lord.
Any
But
person.
High Court cannot declare. High Court cannot declare title.
He was
Kindly see. First, your lordship, kindly see section 17. I cannot.
17 provides a 2.
Who can go before the tribunal?
ওইটা দে, 76
Any person aggrieved.
Right?
Any person active. কি বলছে?
Any person, including borrower, aggrieved by, have you lordship got me? By any of the measures referred to in subsection 4, subsection
Yes.
30. Kindly take note of. Taken by the secured creditor or his authorized officer under this chapter may make an application along with such fee as may be prescribed to the debt security tribunal having jurisdiction in the matter within 45 days from the date on which such measure has been taken. Kindly take note of, my lord. The another flap I have given, section 13(4). Your lordship, may I give one? In case of the borrower fails to discharge his liability in full within the period specified, so the secured creditor might take outcome on one more of the following measures to recover. So I am nothing.
13-4, the bank or the secured creditor has taken steps.
Yes.
Section 17 gives you the power
No,
to challenge that.
again, not under section 13(4).
Yes, sir. Anyone
Under section
agree-
13(4), if any debts is there. So far, I am, my lord, subject to your lordship consideration. If your lordship kindly just me give some time. This is a case where I can show to your lordship all together, all the court's past order in my favor. Just give.
This is the reason you take all these documents to the tribunal and get the order
I cannot under section, kindly, 1 second, read my lord, section 17. 1 second, read, kindly take note of. I cannot. Right to appeal, kindly take note. Any person, including borrower, aggrieved by any of the measures referred to in subsection 4 of
Right.
subsection 13. The measures means, my lord, taking loan. That under section.
No.
13(4). I
Sir,
cannot.
This act is quite old
Yes.
and there are
No.
n number of judgments
Yes.
in section 17.
But
that
your lordship, kindly allow me 2 documents I shall show to your lordship.
I will not look at any document. The read code doesn't have this power. The
So far the notice is
jurisdiction.
concerned, it is attached my property where the
No
division bench of our high court says.
No, sorry. Please come. The petition.
Today is the sale date. Sale notice has been issued, my lord.
should have approached the tribunal earlier.
I have not been intimated anything. Day before yesterday, it had been handing over in my property. And in terms of the court.
Well, let them approach the tribunal. Sale will not confirm
Court
today itself.
directed to get access to me also.
They can
Division
approach
bench.
now.
Check up whether they have got
Nothing. All orders I have annexed.
purchasers. No purchasers.
Oh,
So the no sale will take place. You have got enough time. Go to the tribunal.
but in that case, your lordship kindly record it, my lord.
I will record.
My lord, I am filing a report on behalf of the state, my lord.
No. What to be recorded?
By the steps taken
Grateful to
by
it.
the secured creditor to recover the loan amount. Stand of the writ petitioner is that the petitioners is that they have never taken any loan from any bank. The property of the petitioners has never been mortgaged to the bank. According to the bank, steps according to the bank, steps have been taken for recovery of the loan amount which was disbursed in favor of. Is the borrower a party?
Borrower is not a party.
Not a party, because I don't have any grievance
Borrower
against
is
Borrower
not,
is not a party.
not a party.
Intentionally
This is
not made borrower's
my
party.
case.
Against one, Messrs. Ma.
His land he is claiming to be him.
Rice Mills
Yeah.
Private Limited.
Rice means no, potato.
Potato freezing.
Potato freezing.
No, no, rice mill. Jagatpuri rice mill.
What a
Here
potato
it-
freezing.
According to the borrower, comma, the writ petitioner has encroached upon the property of the borrower. Stop. It appears that civil suit is pending adjudication between the writ petitioner and the
No, still shoot is pending.
Section
no,
seven.
No,
আচ্ছা তাহলে এটা হবে না
Section
17.
no posting in
the,
respect of
the
my claim.
borrower has already approached the debt recovery tribunal for relief
Is a number.
by filing essay being 352/2023. Stop. The according to the writ petitioners, comma, the bank ought not to take steps to sell the property of the private property of the petitioners, as the said property is not mortgaged with the bank. Stop paragraph. It appears that there is a dispute with regard to the identification of the property,
But may I,
which was which is the subject matter of the loan. Stop. The writ court is not the competent forum to adjudicate such issue. Stop. There are enough provisions in the securitization and reconstruction of financial assets and enforcement of security interest act, 2002. Stop. The instant writ petition stands disposed of with the observation that it will be open for the parties to take necessary steps before the competent forum in accordance with law, if so advised.
Grateful.
I'm grateful to that.
Service is taken on
their
record.
submission may be recorded by the.
But is it your lordship pleasure to record my submission?
A report
But it
by
is his
the
lordship
state-
pleasure to record my submission that we are selling the mortgage property only. We are only selling
Achha, state- the
the mortgage
bank,
property,
the
nothing
bank
else.
asserts that apart from the mortgaged property, comma, the bank is not taking any steps to sell any other property.
Kindly record, my lord, that we are
Selling
disputing
any
the
other
submission of
property.
Mr. Bush.
Grateful to my lord.
Yes, I have recorded the
Record that I am
disputed.
disputing the submission of
Yes,
Mr.
yes.
Achha,
My lord,
the
kindly record
submission of
report
the
is filed.
bank is disputed by the petitioners. Your book, please.
But there may be a submission, my lord. No customer has yet been reached. No, this is their submission that can be recorded.
no. Grateful, my lord.
But I am appearing on behalf of state.
Yes.
But, here, my lord, the petitioner, my lord, has been deputed to a school.
Petitioner?
Petitioner has been deputed, my lord, to a school, my lord, to a vacancy, which is, my lord, earmarked for this scheduled tribe category.
All right.
So, my lord, what happens here, my lord,
Where is the commission?
commission, my lord, this has been done, my lord, by the commissioner of the school education.
Let me see.
So, if
But the vacancy must have been forwarded by the board.
my lord, that your lordship will see that if I take your lordship, my lord, to page number 22 once.
Yes, please.
22, your lordship will see this is a letter dated 29th of January 2026.
Yes.
Where my lord Uma Singho, which is the petitioner before your lordship, my lord, he has been present school is this and proposed school is such and such. So my lord, the letter says that with reference to the above undersigned is directed to inform him that his proposal for his means, my lord, the deputy director of the school education granting it. I do not know whether he has got the authority at all, be that as it may. To inform that this proposal for service placement of the following two teaching staff to such and such school has been approved by the commissioner of the school education. Then my can you turn over to page number 24. Page number 24, the district inspector, my lord, informs to my school, to me, my lord, that apropos the above matter enclosed, find here with a copy of the deputy director of the school education grantinate, will speak for itself. She is hereby instructed to join at such and such school and render her service in the same capacity as stated. The lordship, thereafter, my lord, memo copy, lord, at the bottom of this particular page, your lordship will see that memo copy forwarded, serial number 2. SI of the school is hereby instructed to send the joining report of Uma Singh. So I am immediately, my lord, sent to be released and to join, my lord, over there. If I last, my lord, take your lordship to page number 28 once.
Yes.
But 28, your lordship will see this is the vacancy position, my lord, of this particular school where, my lord, I have been deputed. So my lord sees serial number 3 would be, my lord, Nitai High School. So there, my lord, at the top, my lord, it is written bioscience upper primary. Has your lordship got this at the top?
Yes.
And thereafter, my lord, the vacancy medium is Bengali and the vacancy category is scheduled tribe. My lord has seen that.
Yes.
So there, your lordship now sees, my lord, serial number 3, Nitai High School, Nitai such and such, Paschim Medinipur. The vacancy is there in that particular school. So this particular vacancy is basically, my lord, for the scheduled tribe vacancy. And
You are a general category
yes,
candidate.
yes. My recommendation, my lord, shows that I'm a general category candidate. So, my lord,
This is
but
a
apart
vacancy
from this,
list.
yes.
DI, have you got any instruction?
Yesterday evening, I have received the brief. My lord,
Alright.
one humble prayer for your lordship. Kindly have a look to page number 25. This is the order impugned, my lord.
Yes.
My lord,
25
this
is
is
not the order name. It again.
annexure P3, which
Not
I
the order
have
name.
served. In my petition, it is 25 annexure
Yes, but
P3.
it is not the order impure.
No, this is in the May 25. Now it is 26.
Yes, thereafter he made a representation before the, this is a representation or the reply. And
No, no, don't do that because that is long over.
And that is
That
considered.
is not the issue.
Then, my lord,
Issue is whether the petitioner, being a general category candidate, can be directed to be transferred in a vacancy which is reserved for the ST.
ST.
Yes.
Then
The
give me
point is
time.
there.
Instruction.
Time. No, give me some time.
But then in the meantime, her date for joining is there.
Yes. My lord, kindly, my lord, stay this operation of this particular, my lord, memo of.
My lord, one humble prayer. Give me short time, my lord. Within time, I will come back.
Can you come?
Day after tomorrow, my lord. Only one day kindly given me there so that, Lord, do not
Petitioner
give me.
is aggrieved by the.
My lord, cinema, lord, take the talk with the authority so that in this meantime they do not do anything.
কি বললাম? Is aggrieved by the recommendation for transfer issued in her favor in a school where vacancy is reserved for scheduled tribe candidate. Stop. The petitioner is a general category candidate. Stop. Submission is that that a general category candidate ought not to be recommended for transfer in a vacancy reserved for the scheduled tribe. Stop. Learned advocate representing the district inspector of schools seeks time to revert with instruction. Stop. On such prayer, released on 26th of February.
My lord,
Stop.
today is 24th, my lord.
One day you said? All right. The release order.
All right, page number 24, my lord.
Instructed to render service 24. Is hereby instructed to send the joining report of Uma. After this 30th of January, there is nothing.
Nothing. My lord,
Right.
My serial number 1, lordship has seen in page number 24.
Yes, yes.
It says that sub-inspector of the school such and such.
Yes, yes, I've
to
seen
hereby
that.
instructed release Uma Singh. And
Let
then,
us see what happens.
My lord, kindly.
Are you still there in the
yes. I'm still there in the previous
existing school?
Existing school.
All right, you stay there.
My lord, I am deeply obliged.
It will be under the heading urgent motion.
Grateful, man. But the affidavit of service, my lord, be kept.
Yes, yes, yes.
I am deeply obliged.
Okay. Dismissed.
I'm waiting for secondary board.
Well, I am for the petition. Well, I have three-fold prayer in this writ petition. Well, my first prayer is that petitioner, who is an assistant teacher of a school, he was not allowed to join since April 2024. But after filing of the writ petition, he
The
joined.
grievance has been redressed.
He joined in February.
All right. So you do not want to proceed?
No, another writ is the his salary has been withheld without notice since April 2024.
Because you could not join.
Oh, but Lordship kindly said that is my writ petition, But after joining the school, he has been he was paid salary, but very irregularly, 30 days delay, 20 days delay. And my another prayer is that to consider the memo, annexure P20, page 100, extraordinary leave without pay to be considered as extraordinary leave with pay. During the COVID period, as all government school was closed. Now, this is second round litigation. Lordship kindly see, first writ petition, annexure P1, page 38.
Page 100.
Yes, page 100.
There is a continuation page 2. I do not see that. Considering the overall aspect and as for the proposal of the other, please to
Yes, page 100.
Without pay. You want this to be with pay?
Yes,
See, period is 1st of February 19. There was no COVID. Right? To 14th of July 2022.
Yes,
COVID was only from March 20.
Yes,
Prior thereto, there is a 1 year you were absent. And you want to
that was
get
considered,
pay?
That was considered as that was considered as extraordinary leave, without pay.
There is a provision for appeal over here?
No, my lord, there is some different, my lord, which my learned friend is not placing.
No, my lord,
My lord, this absence,
this
absence, my lord, before Justice Mantha, your lordship,
Yes,
Justice
that's
Mantha
why I'm
directed
placing
this
my
3
lord.
years absence as break in service.
Yes, my lord, I am placing now.
Thereafter, my lord, appeal preferred. My lord, the appeal, my lord, division bench modified to the extent, and there was also a deduction for initiation of DP in the before Justice Mantha. Thereafter, division bench, my lord, there is a little modification where the division bench said not break in service, but that 3 years to be considered an extraordinary leave without pay, and not to initiate DP. So, my lord, and directed board to give hearing to consider this leave without pay and regularized as extraordinary leave. So,
That has
this is
been
the
done.
hearing order of the board,
No, my lord,
where
against
the order
that,
of the division bench has been
my
followed.
lord, against that, my lord, we have filed a review petition. Now, my lord, lots of
Review where?
before the division, my lord.
That is pending.
Honorable division, no, my lord, that was disposed.
Disposed of, dismissed.
Disposed of. No,
Dismissed.
this is not dismissed,
Dismissed.
my lord. No, Lordship, kindly see the order, my lord.
What remains in the writ petition?
Lordship, kindly see the order, my lord.
Review.
Where is the division bench's order?
Well, a division bench order at page 45. The relevant portion, your lordship, paragraph 2. Starts from paragraph 2.
And then your lordship kindly takes page 73, order of the review.
Page 71 is the, my lord.
Page 73, lordship kindly.
73.
73, operative part.
Yes, my lord.
Paragraph 11.
My lord, the authority concerned is required to consider the issues with regard to extraordinary leave on the basis of the materials to be disclosed pursuant to the observation and direction first by the President ad hoc committee.
That has been done.
That has been done.
My lord, against that order, my lord, I have come before your lordship.
I do not see anything, any error on the part of the respondents. They have acted strictly in terms of the division bench's order.
No, my
Please
lord,
come.
my lord, what happened, my lord?
Moreover, in the
Extraordinary-
hearing, my lord, he didn't appear. Even before the DI, the hearing was given, he didn't chose not to appear.
The
My lord,
petitioner
he appeared, my lord. He appeared, my
chose
lord.
not to appear.
My lord, he appeared.
challenges the order passed by the Deputy
And
Secretary
my lord,
within bracket General,
extraordinary
West
leave
Bengal
period, my lord,
Board
that
of
is covered also, my lord.
Secondary Education.
My lord, corona
Filed
pandemic
memo
period,
dated
lordshiply
31st
consider.
of December 2024. Stop. The allowed extraordinary leave to the petitioner without pay from 1st December 2019 to 14th of July 2022. Stop. It appears that the said direction is in consonance with the direction passed by the Honorable Division Bench of this court on 14th of September 2023, wherein the court directed the board to consider the prayer of the petitioner for extraordinary leave without pay. Stop. The board afforded opportunity of hearing to the petitioner. When, however, the petitioner chose to remain absent. Stop. Upon considering all records,
My lord, petitioner, my lord, duly appeared, my lord, and submitted all documents, my lord.
All right.
My lord, I have placed, my lord, I have submitted in my writ petition, my lord. My lord, my pleading is there, my lord. All documents regarding, my lord,
the board appears
government
to have
circular
acted
during corona pandemic
in
period.
accordance with the
School was
direction
closed.
passed by the Honorable Division Bench. Stop. The court does not find any error in the impugned order. The writ petition fails and is hereby dismissed. Next.
Item number 9. Lord, he.
Next.
Lordship, picked up of the petition and in this matter is regarding about the non-payment of arrears salary. Your Lordship, in a similar circumstances, passed the order which is filed by me, Your Lordship.
Let me see.
Same scope.
Your affidavit of service?
Renewal will be different, my lord, and amount will be different.
The dates will also differ?
Different.
Petitioner is Deepankar and this is Shivli. সব শিগুলো হি হবে। When did the petitioner join the school?
Your Lordship, petitioner joined the school which is annexed in the joining report, page 14, 19/9/2016.
19th September 2016. I understand the dates are all correct.
Yes.
All right.
Yes.
And approved?
Approved in service, Your Lordship, in 21st February 2018, Your Lordship, which is annexed page number 15.
All right. And the arrear salary not paid?
Arrear salary not paid in due to the joining period to the approval 19/9/16 to 21/2/2018.
21 and not 28?
21 February 2018, Your Lordship.
Is it 21st or not 28th?
No.
Because in Shivli it was 28.
Yes, Your Lordship. But in
here it is 21st.
21st, Your Lordship.
All right.
Page 15, Your Lordship.
All right. Disposed.
My lord, one correction might be, Your Lordship. Page number 18, Your Lordship. It will be 19/9/2016 to 28 February 2018. Your Lordship. Pardon me, Your Lordship. Grateful, Your Lordship. Grateful. Item number 8, my lord, by evident service. Service.
This is my application, my lord. Well, I am a retired military employee.
Your other side?
Service has been. Huh? Service. এটা রিসিভ করে কোথায়? Upgradation.
নোটিস অফ আপগ্রেডেশন দেখুন তো কবে আছে? মিস্টার ভাস্কর বৈশ্য, রঞ্জন সাহা।
Item 10. কি রে 10 এ আছি আমরা? 11 বললি? 10. 10 লর্ডশিপ।
These my lord, the petitioners, your lordship, are the my lord retired military employees. They have been my lord after retirement, my lord, participating in the interview, my lord, called by the government of West Bengal school, my lord, for employment group D, and their salary was my lord fixed as per the notification of my lord, June 2010, and ultimately they have been allotted, issued the my lord, pay, my lord. Subsequently, when all in a certain month, my lord, the respondent number 6 issued a subsequent memo cancelling the no, which has been fixed by me, that is cancelled without concurrence of the finance department. That is my allegation, my lord. He cannot do it, my lord.
Show me, please.
My lord,
Are you ready with instruction?
Why
No.
no instruction?
Only, my lord, in this matter, my lord, at
But
this
lordship,
juncture,
matter
nothing.
pending before the DI or Commissioner of Education. If the let the lordship.
Is it, did you file any representation?
Yes, my lord, I filed.
Where is it?
My lord, it should be hard on evidence, my lord. At this juncture, I am.
It's to be hard.
My lord,
Where is the impugned order? Please show.
my lord, kindly come on the page, my lord. 38, my lord.
No. 2019 order you are challenging in 2025.
No, my lord. Subsequently, I giving my lord the representation, my lord.
Where are the representations?
Kindly come to my lord page, my lord. Page 15 onwards, my lord.
15?
Yes, sorry, my lord. 51 onwards, my lord.
51 onwards. Is there any reply from the end of the respondents?
No.
Let them consider
Lords, they did.
being aggrieved by the order dated 20th August 2019. The petitioner filed representation before the respondents.
My lord,
Where is the representation before the Commissioner of School Education?
my lord, last my lord, page 66, my lord. 21st October 2025.
So 19 order and 25 you filed the representation.
Then my lord, kindly see my lord, page 50C also there, my lord.
Show me.
Kindly. 52, my lord, kindly see my lord.
52.
My lord.
Where is the proof of service? Where is the proof of service?
No service, only for the letter.
No, it is served, my lord.
Show me.
Last lordship, place 66 here only for the evidence.
No.
Otherwise,
Here also there, it is postal track report is also there, my lord.
66 only the track report is there, otherwise nothing.
possible lordship, 6 year after that.
Yes.
Lordship not independent.
Before the respondents in October 2025. Stop. Allegation is that the same has not been considered till date. Stop. The learned advocate representing the state respondents opposes the submission and prayer of the petitioners. It has been submitted that the representation has been filed after considerable delay and no direction ought to be passed for consideration of the same. Stop. Upon hearing the submission made on behalf of both the parties.
There is a receipt. Page 59 can see. 59 can see, my lord. There is a receipt, my lord. My lord, if, in that event, my lord, kindly, my lord, adjourn the matter. I will come back, my lord, with the receipt, my lord. Page 59 can see, my lord. That was a
Page 2010.
2020.
After 5 years.
No, why after 19? Your order is 19, August 19.
Yes.
Then 20.
1 year. Now is the 2020.
Bhai, August 18 or it was October 20.
2 years, sir.
My lord, before that, the representation, I will come back with the, my lord, receipt of the department. May I come back there? Kindly adjourn the matter, I will come back.
No, sir. You have mentioned the matter seeking upgradation, citing urgency, and at the time of call, you want to take time. And you have not annexed document. Show from the writ petition that you have filed, other than I'll consider.
Well, I want epidemic I am on oath. I am stating before Lordship, my lord.
As it appears that the petitioner applied before the Commissioner of School Education
at least 59 your lordship kindly consider, my lord. Page 59 kindly see, my lord.
2020.
October 2020, my lord.
Page 59 has got nothing to do with page 38. It has got nothing to do.
No.
Nevertheless, if you say to consider page 59.
Well, therefore, my lord, we request, my lord, paragraph 2 kindly see, my lord. Therefore, we request you why we are treated as a new employees because of this, my lord. The payment has been given there, my lord. But in the memo by which we have been appointed, last paragraph, my lord.
In October 2020.
6 years, lord.
6 years, 19 and 26 years.
2026?
2026, the last repayment, the first repayment.
Praying for certain service benefit. Stop. Without entering into the claim of the petitioners at this stage, the instant writ petition stands disposed of by directing the Commissioner of School Education to consider the representation filed by the petitioner on 14th October 2020, page 59.
Along with my last.
There no lordship. There is no annexure lordship. Only for that lordship 2020 is the lordship.
Please start consider the aspect, my lord.
Only for the lordship 2020.
Along with the
last
representation.
66.
But no annexure lordship. If the lordship I have not received that document lordship, how it is possible?
Dated 21st October 2025. In accordance with the prevailing rules. At the earliest. But positively within a period of 12 weeks from the date of communication of this order. Stop. A recent order shall be passed and communicated to the petitioners immediately thereafter. Stop. It is made clear that this court has not entered into the merits of the prayer of the petitioner. And it is open for the Commissioner of School Education to take a decision in the matter in accordance with law. Stop. Learned advocate for the petitioner is directed to forward a copy of the impugned order dated 20th August 2019 along with the copy of the representation dated 20th October 2020 and the representation dated 21st October 2025 to the aforesaid respondent at the time of communicating the order of the court disposed. Next. Notice of upgradation.
That in the list, well, the monthly list numbers are mentioned.
Yes, but you should intimate your other side. Who's there? You do not know, no idea.
For the first time. Well, may I come back tomorrow?
Tomorrow, how can the other side get to know?
No, I will give notice to him personally.
None appears on behalf of the respondents. Stop. The matter has been upgraded citing urgency. Stop. Release the matter on 2nd March.
Second. Great. But he's
Are you there?
Yes, I'm there, but I need to take instructions on
Item 11.
11.
Yes.
But may I start for 2 minutes?
Oh, what is your submission? You want to take instruction?
Yes, ma'am.
But I'm
Why did you
questioning
not
the.
take it? It's a 2025 matter.
My lord, this is my lord cover for the first time, my lord. It was running in the monthly. I'm sorry, my lord. Let me say.
May I?
What is your prayer?
Only 1 minute. But this is a recent order. It is
11 number. 11 number.
But this is regarding compassionate appointment. My case was lastly rejected, page 35.
Yes.
33 is the order. 35 is the resent order passed by the district inspector. On the gross income, 697. My lord, here, Lordship, kindly have a look to page 51, my lord's judgment on 697.
1 minute. Page 35. What is the reason?
37 is the reasoning part. Gross income.
Gross income 20,000. Huh?
Gross income of a Group D staff under the government of so-and-so at the material point of time. But GO number 697, which I have annexed to this petition, has been considered by the district inspector. But I have annexed your lordship's judgment at page 51 dealing with 697. And it is in a very recent judgment, Justice Om Narayan Rai has considered my lord's judgment and passed a detailed judgment, which I want to cite before your lordship. But that judgment has been complied with by the district inspector of schools, Purva Bardhaman. Now, kindly turns to page 51. Your lordship has passed a detailed judgment on this 697 and directed page 56.
Yes.
It will settle last paragraph. Got it? It will settle law that compassionate appointment cannot be claimed as a matter of right, and the same is an exception to the general so-and-so. Then, strictly in accordance with law, it is only if the petitioner is able to satisfy. But for the amount received as family pension, the financial condition of the family is such that they cannot afford to have 2 square meal a day. Then only the prayer of the applicant petitioner for compassionate appointment may be considered by the authority. At the same time, while considering the financial strength of the family, the authority cannot take into consideration the amount received by the widow as family pension. In view of the above, the impugned order rejecting the prayer of the petitioner being considered for appointment or compassionate ground is set aside. The matter is remanded back to the petitioner. I have a point in this. But at this time, probably this is the 3rd resent order passed by the same authority on same point. So, kindly do not.
697.
Yes, I have all the orders annexed.
Please show.
But kindly have a look to what High Court has said. Because this is page 38. Kindly have a look. This is the written notes of argument I placed before the DI. The order of my lord was there attached to the annexed to the written notes of argument. In spite of that, and Justice Mantha's order I have also annexed. And I have also annexed the notification 697. My lord, can I have a look too?
Justice Mantha's order is in which in respect of the same notification?
No, on compassionate ground and on page 49 on the family income. To Justice Rai judgment and Justice Rai also, Om Narayan Rai. Is in complete agreement of your lordship's judgment. এটা একটু জশাবকে দিন। Page 32 is the earlier order of the DI in 2024 on 697, which has been quashed by the High Court. Page 33. Again, page 35, 697. Well, in the written notes of argument, I have annexed to your lordship's judgment.
No, family income of the petitioner, they have calculated family pension also. Right, income from salary of Krishna Sarkar, wife of deceased at the material point of time. And the family income of the petitioner, 46,000. That means 46,000 is the family pension, which was taken into consideration. Whose family pension is this? Who was the teacher?
My father.
Your father. And so family pension your mother was receiving. This has been taken income of salary of Krishna Sarkar, your mother.
Krishna Sarkar is my mother.
Right. Wife of the deceased at the material point. Your mother is also an employee?
She retired. She was an employee.
She retired. She was an employee. All right. So this is the differentiating factor. The pension of the father, even if it is deducted, then also the mother's pension, then the widow pension all comes in and the figure increases.
Absolutely.
Then how will you fall in penury?
Well, may I place 697? The notification they have, kindly have a look. Page 58.
Yes.
But here, page 74 is the operating part.
74.
Yes. The procedure, manner of application, and preparation of panel for appointment on compulsion ground.
Yes.
It said, when a teacher, non-teaching staff, I'm not reading it, thereafter explanation. The expression financial hardship in relation to income of a deceased teacher or non-teaching staff consisting of 5 members in his family shall mean an amount of income not less than initial gross salary of Group D staff of the state government at the material point of time. For computation of income of such family, an income of an amount earned by each family member from any other source than Provident Fund gratuity and 40% of the family pension of the first 7 years or upon the attainment of 67 years of the age of the deceased teacher, had he been alive, whichever is earlier at the material point of time shall be taken into account. This is first. Then, provided that if the family of the deceased teacher exceeds...
No, don't go to that because you are not exceeding 5 persons, right? Don't go. Here, it has to be the family shall mean
up to 5 members.
Right, so you fall within this.
Yes.
Shall mean an income of amount of income less than the initial gross salary of Group D staff of the state. And when did your mother retire from service?
Well, my mother retired 2 years back.
So 22, your mother was in service.
Yes.
How do you claim compassionate appointment?
Well, my father expired. Kindly have a look to the date of his expiry.
Yes.
Well, the death certificate I have annexed. Well, he expired
17th of April 2022.
22. Yes. Page 20.
17th April 2022. Your mother retired from service when?
In 24. She was in service. But kindly have a look to the impugned order once.
How do you get service, sir?
My lord, may I?
Yes.
My lord, 697 has been quoted by the DI at page 35. My lord, explanation he has quoted. Then page 36. So,
No question of family financial hardship in this case.
but at the material point of time, Krishna Sarkar, the widow of a deceased teacher of so-and-so, was assistant teacher of so-and-so. Her monthly gross salary was so-and-so, deducting rupees so-and-so as monthly subscription of the GPF. The family pension stood 46,000 at the material point of time. So the total family income of the family was 1,27,000 so-and-so at the material point of time. So the word financial hardship is not applicable for the family member of 2 persons. That is me and my...
No, sir, cannot be done. Please come. The petitioner is aggrieved by the order dated 5th of February 2025, passed by the District Inspector of Schools, Secondary Education, Uttar Dinajpur, rejecting the prayer of the petitioner, seeking compassionate appointment. Stop. The finding of the District Inspector of Schools is that there is no financial hardship in the family of 2 persons. Stop. Paragraph. The father of the petitioner was a teacher who died in harness on 17th April 2022. Stop. The mother of the petitioner, also a teacher, was in service on the date of death of her husband. Stop. The authority calculated the family income of the petitioner on the date of death of the employee and came to a considered opinion that there is no question of financial hardship in the family. Stop. Paragraph. Learned advocate for the petitioner stresses on the fact that the pension received by the widow, family pension korun, ought not to be taken into consideration at the time of calculating the financial income of the family. Stop. Paragraph. The petitioner relies upon several precedents in support of the aforesaid submission. Stop. Even if the submission of the petitioner with regard to family income is taken to be correct, the petitioner cannot overcome the hurdle of receiving the hurdle of the income received by his mother, who was in service, government service, on the date of death of his father. Stop. The mother of the petitioner retired in 2024. Stop. The authority ought to calculate the financial income of the family on the date of the employee. Stop. On paragraph, in the instant case, on the date of death of the employee, another member of the family was in government service. Stop. A family of 2 members where one enjoys government service cannot claim to be in financial hardship. Stop. The total family income of 2 members calculated by the authority is rupees 1,27,291 at the material point of time. Stop. With such financial income, a family cannot be said to be in financial hardship, so much so that the application for compassionate appointment is to be considered. Stop. Paragraph. It is well settled that the that compassionate appointment cannot be claimed as a matter of right, and it is only considered for tiding over the immediate financial crisis faced by the bread earner. Stop. Inclined to interfere with the impugned order. Stop. The writ petition fails and is hereby dismissed.
Great.
Next.
My lord, item number 12, my lord, I am for the petitioner, my lord. It's
Yes,
for
please.
higher pay scale, my lord, pending at the end of the district inspector of schools.
Covered by Utpal Kanti Karan?
No, my lord. My lord, here, my lord, initially I was in a school at Murshidabad, my lord.
Anyway, if you say it is pending, let them consider.
Yes, ma'am.
Page.
Page 37.
The petitioner's prayer seeking higher scale of pay on enhancement of the educational qualification is pending consideration at the end of the District Inspector of Schools, Secondary Education, Barasat. Stop. Without entering into the merit of the claim of the petitioner, the instant writ petition stands disposed of, directing the District Inspector of Schools, Secondary Education, Barasat to consider the petitioner's prayer for higher scale of pay, strictly in accordance with the prevailing rules at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. An opportunity of hearing shall be granted to the petitioner, the school, and any other necessary party for ascertaining the claim of the petitioner. Stop. If the claim of the petitioner is allowed, then necessary consequential steps shall be taken by the aforesaid respondent. Stop. Writ petition disposed. Learned advocate for the petitioner is directed to forward a copy of the subject representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court.
My lord, the affidavit of
Service is taken on record.
Item 13, I beg to appear on behalf of the petitioner, my lord.
I am for the secondary board.
My lord, what happened? The petitioner was appointed in 1991 as a organizing non-teaching staff of the school in question, my lord. Thereafter, my lord, the DLITD inspected the school and the petitioner's name found there in serial number 13. Thereafter, one writ petition was moved before this honorable court, and this honorable court directed the authority to consider the recognition, and ultimately recognition was granted, and thereafter a pair was made.
When did you retire? Please tell me.
Now, my lord,
what is the shortfall?
50.
Shortfall. What do you want?
My lord, others, non-teaching and teaching staffs was granted, my lord, appointment. In view of this honorable court's order, I have annexed some of the.
How many days short?
My lord, my case was not considered. When this honorable court passed this order, my lord, for consideration of the appointment, and appointment was given to the others, and I had made a representation before the district inspector school annexing the order of this honorable court. There is last annexation, my lord. Kindly see page, my lord, 64.
You want this to be considered? You want this to be considered?
Consider means, my lord, any instruction is, my lord, taken by my learned friend, whether why not my case will be considered? But similar footing, my lord, similar footing.
Only one sanctioned post, non-teaching staff, is already there, who has been considered. Now he is the second one. Yeah, unless until the school moved matter with the department.
The petitioner's prayer.
This is my report, madam.
All right, please give. The petitioner's prayer for grant of approval of his service is pending consideration at the end of the Commissioner of School Education. Commissioner of Education Department. What is this designation?
My lord, that is, my lord, wrong.
No designation.
Government was not because I have seen, my lord, it is.
Acha. Learned advocate representing the petitioner submits that similarly circumstanced persons have been provided approval of appointment,
That is under the order of the court.
whereas
Yes, that's
the
under the
case of the petitioner has been ignored. Stop. Prayer has been made to direct the respondents to approve appointment of the petitioner from the date of recognition of this school, that is 20th December 2002, and other ancillary relief. Stop. Learned advocate representing the state respondents relies upon the instruction forwarded by the District Inspector of Schools, Secondary Education, Noida,
Paragraph 15 and 16, my lord.
wherefrom it appears that there is only one post in the there is only one sanctioned post for clerk in this school. Stop. One candidate has already been appointed in the said sanctioned post. Stop. As on date, there is no vacancy in the school where the petitioner can be appointed or his service may be approved. Be that as it may, as it appears that the petitioner's representation is pending consideration at the end of the Commissioner of School Education, accordingly the instant writ petition stands disposed of by directing the Commissioner of School Education, to consider such representation strictly in accordance with law at the earliest.
In the light of the judgment of this honorable court.
But positively within a period of 12 weeks from the date of communication of this order. Stop. The Commissioner of School Education shall afford an opportunity of hearing to the petitioner, the school authority and the representative of the District Inspector of Schools at the time of consideration of the petitioner's prayer. Stop. The order passed by this honorable court on 2nd May 2024 in WPA 6713 of 2016.
That has been considered.
In the matter of Rukhsona Begum and others shall also be taken into consideration at the time of passing final order in the matter. Stop. A recent order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, the necessary consequential steps shall be taken.
I deeply object. নামগুলো দিয়ে দিস
Your Lordship, I am for the petitioner.
For the secondary board lordship.
My learned senior is online, my lord. I am subject to affidavit of service.
Your Lordship, I am appearing for petitioner, Your Lordship.
Before moving the application, I submit that petitioner has taken the notice because the school, my lord, but then return the same till date, my lord.
Petitioner has taken
Notice book. Which has been
notice book. You use the microphone. Somebody is there online.
Your Lordship, I am for the petitioner. Let me submit my case first, Your Lordship.
School property, but he is not.
School property taken away by the petitioner. All right, let me hear what the petitioner has to say. Yes, please.
Your Lordship, the present petitioner before Your Lordship, is the president of managing committee of Mohanpur High School, Your Lordship. Your Lordship, kindly turn to page 26 first. This is the order by which the present petitioner was nominated, in fact, as the president of MC. Page 26, Your Lordship would found it.
Then what happened?
Now, petitioner took charge. He was acting during his tenure. Your Lordship kindly comes to page 7, Your Lordship, page 7, para 8 and 9. As a president of the managing committee of the school, the petitioner found several irregularities with regard to operation of bank
Your
account.
nomination has been recalled in October 2025 and somebody else has been nominated.
Yes, Your
Right.
Lordship.
This is under challenge.
Yes, Your Lordship. I have challenged that order.
Yes.
Now, during my tenure, when I was working as the president of the managing committee of the school, I found several irregularities with regard to operation of bank account of the school, as well as huge scam, large scam with regard to midday meal yield receipt. I have mentioned it in para 8 and 9 at page 7 yield receipt.
What do you want now?
Your Ladyship, I have challenged that order by which my nomination has been recalled. First, secondly, I made a representation before the state respondent number 10, who is the district inspector of school. Your Ladyship would find that at page 35, my representation at page 35. Now page 36, page 35 is the representation which I made before the state respondent number 10.
Your recalling order was passed by the Deputy Secretary.
Yes, Your Ladyship.
To the government of West Bengal.
Yes,
so
Your Ladyship.
That is a different authority. Your representation before the DI is also something different.
Your Ladyship kindly turns to next page. Your Ladyship kindly sees page 36.
Yes.
This is the correspondence, the copy of which was given to me.
Complaint has been received. Such and such. So the notice of declaration has not been served upon the
11 teacher in charge of that school.
And not sufficient. He is informed this office with the managing and his constitution they did not. Then what has happened? After page 36?
Your Ladyship, even the from page 36, it would be evident that even the state respondent number 10 kindly sees his observation how the new managing committee has been reconstituted.
Who is appearing for the state? Did you give notice?
Yes, Your Ladyship, I have served. And I have
Yes, and notice also served, my lord.
Who is appearing for the state? Did you serve notice?
Yes, madam. Every service also
See,
given,
the
madam.
name must be there. You should have served notice of upgradation. This is an upgraded motion. Ms. Bornali Gupta.
Yes, Your Ladyship.
Advocate for the state. Where is she? Call her. None appears on behalf of the state respondents. Stipulate further notice be issued, released on 2nd of March 2026. Affidavit of service filed in court. Affidavit of service and the notice of upgradation filed in court be written with the records. Are you holding back any property of the school?
Ladyship, I'll have to take instruction from my client, Your Ladyship.
I have requested him, Lord,
As on date, personally, I am not aware as to this, Your Ladyship.
I have requested him personally, Lord. Lord, could you tell them, Lord?
A learned advocate representing the school submits that the petitioner has taken away the notice book of the school. Stop. Learned advocate for the petitioner shall obtain necessary instruction in this regard. Yes, next.
Grateful to Your Ladyship.
Notice book of the school.
At 15, I appear.
Yes. Other side.
No notice of upgradation, but I
Why?
must be very careful.
What is the urgency?
That this is a double increment on PhD. But I am covered by the order of this court.
Yes.
But your Lordship, kindly have a look to page 23.
You annexed Utpal Kanti Karan. My God, such a voluminous judgment you annexed with your writ petition.
It was the desire of my client. Sometime, but we have to.
No, sometimes you have to tell your client as to what is to be annexed and what not.
But
Should not be.
live streaming is going on, but I may not say.
Because the clients should know that this is not the way how writ petitions are filed. See the volume.
Live streaming is going on, but so
live streaming will be there to make the clients aware that they should have some confidence of the learned advocates and not take decisions. What is your prayer?
But your Lordship, kindly have a look to page 23 and 24 once.
Any representation pending?
Yes.
Where is
My
it?
lord, page 23.
Relying on Utpal Kanti Karan?
Yes, my lord, the school has forwarded my case, my lord, on
To the DI?
to the DI.
In
Bakur,
2022?
2022. Thereafter,
She has completed PhD now called
kindly have a look to the
increment.
reply on RTI,
Yes.
which I have received. But in RTI reply, my lord, they have said that I am not entitled.
Where is
but
it?
the case is, but the result order has not been passed. But RTI reply is not the, but though I have annexed it to the petition.
Show me which portion is cover of Utpal Kanti will cover you.
But yes.
Did you obtain any prior permission? What are the dates?
Yes. I have taken prior permission, but that I have mentioned in the petition.
And the dates and everything are there.
Yes. But in the petition, I have also mentioned, but if your lordship kindly takes up my list of dates, but entire list of dates is like, I have drafted in such a petition, that entire from the entire list of dates,
appointed as assistant
the lordship
teacher.
will get the entire fact.
Permission granted. Faculty member to appear for PhD. You obtained your PhD degree prior to joining the school?
No. But if your lordship kindly have a look too, but I obtained the, I was appointed in 2021 and but the 2008 I was awarded, yes, but 2008 I was awarded the degree.
That means you obtained the degree prior to joining the school, right?
Prior.
So there is no question of taking any prior permission. Then,
regarding the request made by the school for additional increment,
did you disclose your educational qualification at the time of appointment? You did not.
Give me 1 second time.
Where is the RTI reply?
Well, kindly give me 1 second time. Well, if your lordship kindly have a look to, my approval of appointment. In approval of appointment, I have mentioned that I am MA in Bengali and B.Ed.
That means you did not disclose your PhD.
No.
Why? You obtained PhD prior to your joining, and after you join, you will disclose your degree. For what good reason?
But if your lordship kindly have a look, approval order of approval does not speaks of my enhancement of my qualification.
PhD, not enhancement, because you had that. It is not that you
during the course of employment I have,
or after.
Yes. No, this enhancement of qualification I have not disclosed. Now the case is, I am my case is pending before the district inspector of schools pursuant to the request made by the school, page 23.
Yes, that you showed. Where is the RTI reply?
এত বড় জাজমেন্ট আমি নিজেও খুঁজে পাচ্ছি না দেখছি give me 1 second time.
Please come. The petitioner alleges that the request made by the teacher in charge of the school praying for grant of extra increment to the petitioner for PhD degree is pending consideration. Stop. Without entering into the merit of the claim of the petitioner, the instant writ petition stands disposed of by directing the DI of schools Bankura to consider the prayer of the petitioner for grant of extra increment for her PhD degree strictly in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. If the prayer of the petitioner is allowed, then necessary consequential steps shall be taken. Stop. An opportunity of hearing shall be provided to the petitioner for production of all documents.
Grateful.
Petitioner and the school. and all other necessary parties for production of all documents in support of the prayer of the petitioner. Disposed. Service is taken on record.
Great.
My lord, in this matter, I'm praying only not today, my lord, on behalf of Mr. Sarwarja. He is arguing in court.
What is the matter?
What is it? Regarding arrears, sir.
Arrears salary? 2020?
Yes, my lord, at the time of COVID-19 and
31st October 2019.
Where is it pending? DI Paschim Mednipur. Why keep it pending? Let's dispose it off.
But
where is the application?
Lordship, 31st October 2019 till 9th December 2020.
It will be February.
Page 34 is the representation.
Yes.
The petitioner's prayer. Seeking grant of arrears salary. Pending at the end of the District Inspector of Schools, Secondary Education, Paschim Mednipur. Since 2020. Stop. None appears on behalf of the state respondents. Stop. The learned advocate representing the board is present. Stop. Paragraph. Without entering into the merit of the claim of the petitioner, comma, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Bankura, to take a decision on the petitioner's prayer seeking release of arrears salary in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. An opportunity of hearing shall be granted to the petitioner for production of all documents in support of his claim. Stop. If the prayer of the petitioner is allowed, comma, then necessary consequential steps shall be taken. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. Learned advocate for the petitioner is directed to forward a copy of the subject representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed.
My lord, may I file affidavit of service?
Please give.
Yes, I of course.
Please give. Affidavit of service to be retained. Please check up that it is filed prior to the order being signed.
No, I am for the petition.
Other side.
That's why notice. I have in this matter. I am not forgot to give the notice. Other matters.
You forgot to give the notice.
Not other matters I have, but somehow.
None appears for the respondents. Stop. List on 2nd March. Let notice be served. Next.
My lord, I am for the petition.
Yes.
Go to service. My lord, matter relates to my lord, revision of pensionary benefits of the petitioner by treating the service rendered by the petitioner, approved service rendered by the petitioner in a DA getting school.
Show me your PPO.
My lord, PPO is page 19. Page 19, if your lordship 1, 2, 3, 4, fourth line, first date of entry into approved service, 27th March 2000 school, which is fully aided, your lordship. Before that, I rendered service, rendered approved service in a DA getting school. Page 15.
Yes.
Page 15 is my approval in DA getting school. I am serving there from 1st April 1992.
Have you brought the
Thereafter,
judgment? Have you brought the judgment passed by this bench?
No,
You've
not.
got similar orders.
My lord, I have annexed a judgment passed by the coordinated bench. Following the order passed by the Honorable Division Bench.
So in the same line, it can be disposed of? Instruction, yes. Please come. The petitioner retired from service on attaining his normal age of superannuation on 30th November 2024. Stop. His pensionary benefits have been calculated on and from the date of entry, on and from the first date of entry into approved service, that is 27th March 2001. Stop. The petitioner has annexed documents to show that he was approved in, he was appointed and approved in service in a DA getting school on and from 1st April 1992. Stop. It has been submitted that the pensionary benefit ought to be recalculated, taking into his first date of entry in service, that is 1st April 1992, and not from
27th March 2001.
27th of March 2001. In support of such submission, the petitioner has relied upon several orders passed by coordinate benches and the Honorable Division Bench.
Right.
Learned advocate representing the state respondents relies upon the instruction forwarded by the District Inspector of Schools, Secondary Education, Purva Bardhaman, dated 12th February 2026.
Primarily objecting the issue, but
Wherein the authority has opined that the service rendered in a DA getting institution cannot be considered for the purpose of calculating the pensionable service period. Stop paragraph. The opinion of the District Inspector of Schools appears to be contrary to the several orders passed by the court from time to time. Stop. The court specifically held that the right of the teacher to get pensionary benefit flows from memo number 180, page 22. 180-EDNB, dated 20th May 1988. Stop. The government order number 136-EDNB, dated 15th May 1985, cannot be relied upon to refuse the claim of the petitioner. Stop paragraph. Next. In view of the above,
It would be, my lord, 19th April 2006.
Acha. 85 বললাম তো, followed by
85 is the
the
pension scheme.
clarificatory government order number 131 SEB, dated 19th April 2006. Yes. ঠিক আছে? Paragraph. The as any final order appears that the District Inspector of Schools, Secondary Education, South 24 Parganas, now Purva Bardhaman, is yet to pass a formal order on the prayer of the petitioner Accordingly, the instant writ petition stands disposed of by directing the DI to consider the prayer of the petitioner for for calculating his pensionable service period strictly in accordance with law and the prevailing government orders and the law laid down by the Honorable Court from time to time. A decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner. If the prayer of the petitioner is allowed, then revised PPO shall be issued. And the amount mentioned therein shall be disbursed in favor of the petitioner without any further delay. Learned advocate for the petitioner is directed to forward a copy of the relevant decisions in support of his prayer to the aforesaid respondent at the time of communicating the order of the court disposed. Next.
But I am for the petitioner, my lord.
Respondent school, the state.
I have served, my lord.
Notice?
Yes, my lord. Notice also served, my lord.
Yes, who is appearing?
My lord. Somnath Noskot, my lord.
All right. Yes.
My lord, in this matter, my lord, petitioner C had working as a gateman temporary basis in the year 2005. Annexure P1, this page 15, my lord.
Yes.
And thereafter, school has advertisement, group D post, and thereafter, petitioner applied, my lord. And the interview was held, Annexure P2, my lord, page 16, my lord. After this interview, my lord, panel was prepared, and next, page 3, P3, page 17. And this panel, Asim Kumar Ghosh is the first, Bimal Kumar Maiti second. I am the Bimal Kumar Maiti petitioner. And thereafter, this panel I made an application with my learned advocate, my lord, for Right to Information Act. Report given, my lord, to bring appellate authority HM. And after this, my lord, HM has sent a report, kindly page 20, my lord. My lord, kindly see, my lord, page 20.
Yes.
And thereafter, my lord, petitioner made a representation, page 21, my lord, from DI, my lord.
For approval of panel?
For approval of panel, my lord. And this representation is pending.
But at this stage, where is the scope? 2012 panel.
Yes.
And can you pray for any order?
Thereafter, my lord, kindly see next page 33, my lord.
Yes.
After this representation, my lord, headmaster, my lord, he has sent a letter to me, my lord. In respect of your letter, it is to inform you that the school authority submitted a panel 3 along with relevant documents for appointment.
The scope for passing an order for approval of panel after so many years.
Yes, my lord, but headmaster has given so many years, my lord, kindly see.
No, show me the scope. Where is the scope to pass an order in this matter?
My lord, because, my lord, I am working this school, my lord, since 2005, my lord.
I can understand you are working, but the court cannot pass any order directing approval of panel.
My lord, kindly let it be considered my representation, my lord. And my lord, otherwise, my lord, I am working since 2005, my lord.
None appears on behalf of the state respondents. Let notice be served upon the learned advocate, intimating that the matter will appear in the list on 2nd March 2026. Learned advocate for the state shall obtain specific instruction from the District Inspector of Schools, Secondary Education, Kolkata, as regards non-approval of the panel, which was forwarded by the school to the DI way back in August 2012. Panel যেখানে বললাম না, for the group D post in
Annexure P3, my lord.
In name of the school is Borisha High School. Borisha High School. ঠিক আছে? Come back.
Yes, my lord.
You do not have any instruction, not following it up. Service is taken on record. Next. There are order against you.
Yes, my lord.
Yes.
I am for the petitioner.
Yes. Who is your other side?
I have served. Again, I have given notice.
Who?
Rashmi Chakraborty. Also, further notice served and further notice given.
Reshmi Chakraborty?
Chakraborty.
For the state?
For the state. হ্যাঁ সেরকম বলে তো সবাই
My lord, 23, my lord.
22, 24.
3% increment, my lord. There I
All these are with regard to 3% increment to the headmaster. Called by my lordship.
Show me this order that has been passed by this bench.
Market bench passed the order for considering these two commission. It has been sent.
Same order can be passed?
Not be, no, my lord.
Third paragraph.
Geo order.
Third paragraph.
Right now, I got the message from the officer of DI. On the next occasion, I can, if your lordship or if your lordship hear me out.
It can be disposed of it. I think the joint secretary respond number 5.
The 3% increment is because of the upgradation of the school and you are working as headmaster?
Geo number
That is. There is no necessity to keep it pending.
Withdrawn. By Geo number dated 22.
3% increment, we have got usual order.
But there is no Geo existing.
Applicable service.
Without the additional increment.
Your client is not giving you proper instruction. I have passed an order, you check up. It will be covered by that. You take this back. 3% additional increment, several orders passed. Please check up.
Commissioner of Education.
No.
Yes, it will be considered. 20 call 21. 20 you are not appearing. All right.
21 affidavit service.
Same. Affidavit of service, none for the state.
21.
22. 21.
Because it is not announced.
And I cannot. 21.
Yes, my lord.
Give your appearance. Give your appearance, please.
3%.
22.
22.
You are there? Appearance.
Affidavit service.
22.
21.
For state.
23, my lord, I'm appearing.
23, please give your appearance.
Please 24.
24, no application. No application.
Application is not there, my lord,
In
but
none of the matters.
no application in lordship.
All right. 3% additional increment. 3% additional increment. No application filed. Shade of no order আছে.
I shall give.
সব কটাতেই সেটাই করবেন.
I shall give application.
Application 23 also no.
I'm confused. Rightly that is, I shall not.
I am giving you leave to file application. All right. All right. 25.
March of election. End.
From she is coming from annex building.
Higher scale of pay.
My lord,
Is any representation pending? You do not know.
I am not.
I can see a representation over here. Grant higher scale of pay. 54. The petitioner's prayer seeking grant of higher scale of pay on acquiring postgraduate degree is pending consideration at the end of the Commissioner of School Education. Pending consideration at the end of the respondent authorities. Commissioner of School Education হবে না ঠিক আছে without entering into the merit of the claim of the petitioner, the instant writ petition stands disposed of by directing the Commissioner of School Education. No, Commissioner, no. District Inspector of Schools, Secondary Education, Nodia, to consider the petitioner's prayer strictly in accordance with law at the earliest, but within a period of 12 weeks from the date of communication of this order. An opportunity of hearing shall be granted to the petitioner for production of all documents in support of his না her claim ঠিক আছে a reasoned order shall be passed and communicated to the petitioner stop if the claim of the petitioner is allowed comma then necessary consequential steps shall be taken by the authority without any further delay. Page 54 to be considered. Yes?
Petitioner filed earlier writ petition, Lordship. That is.
Now page 54 is pending.
Yes, Lordship.
Let them consider the DI.
That is higher scale of pay.
Higher scale of pay. All right. Disposed.
Grateful to.
Yes.
This is my application for transfer on offline mode in prescribed pro forma. So, my lord, that is pending before the school. My lord, the school has not granted NOC, nor my lord forwarded the application. Your lordship will see my offline application would be at my lord page number 18, and the prescribed pro forma lordship will find from page
But
number,
where is the proof that you
I've said,
filed it before the school?
my lord, your lordship will see
Page
from page number
18.
25. I'm sorry, yes, page number 18, my lord, is the forwarding letter.
And 25 you sent it through post?
Post.
20th of
26,
November
27.
25.
At the
All
date
right.
credit track report.
The petitioner's application seeking transfer filed offline
Yes.
in the prescribed format is pending consideration at the head of the institution.
My lord. On the ground of distance, my lord.
Stop. এবারে usual order to be considered by the head of the institution. ঠিক আছে? Disposed, service taken on record.
Grateful, ma'am.
27 Lordship, Mr. Pratik Dhar, senior advocate, he is appearing for the petitioners. He is engaged in court one at this moment. I'm seeking passover.
Passover will not be possible.
Advocate on record is also with him. That
Yes, what can be done? You mentioned the matter citing upgradation, urgency, and now you say Passover.
I didn't actually. The advocate on record
Anyway,
requested me.
Accommodation has been sought for state on behalf of the learned counsel representing the petitioners. Stop released on 2nd March. Let notice be served upon all the parties. Is there anybody apart from the state? Commission is there. All right. Next.
No, 28, I appear for the petition. Well, the petitioner, I have served the upgraded notice also.
Who is appearing for the state?
SSC. SSC's appearance is required.
SSC?
But here,
Is it a second SLST matter?
But our candidature regarding 10 years, 10 marks regarding experience. Although we have made a representation, has not been considered at the time of verification. Whatever I am telling.
Yes.
We are the teachers of 11-12 section in the earlier selection process. Worked for 6 years, 2019 to 2025. By virtue of the order of the Supreme Court, it has been terminated. Now, we have applied for in two upper madhyamik as well as the higher secondary. Since we are the teacher of higher secondary, we have made that corrigendum that we are the teacher of higher secondary, 10 experience marks should be given. But apart from that, we have applied for 9-10 category also. There,
show me your application form.
Yes, application page 71. In terms of the notice of 70, we have made the representation to the authorities long back of September 29, 71 and 73.
Application, everything is to be done online. There is no scope for filing application.
Because inadvertently, when we had the misunderstanding that since we are the teacher of
whose problem is this? Teachers' misunderstanding to file online application.
Kindly see paragraph 13. I have stated there.
Your stating will not do. The authority is not taking any documents physically. Everything is to be done.
Have accepted the other smaller candidature regarding experience. We have missed it.
You've missed it for all.
Subject to, for that reason, my constitutional right cannot be curtailed. Not subject to correction it is. Because I have every right to be participated along with those documents.
You have not disclosed.
I have not disclosed because of the fact since we are the teacher of higher secondary
So
section.
it is your problem.
Or
It is
subject
not
to
the
consider.
problem
That
of
is
the.
why, my lord, we
No,
our service cannot be, my
the
lord, terminated.
court is refusing such prayers.
My lord, your lordship,
So-
kindly take them note of that.
All right, I'll take note. Bring them. Call Mr. Singh.
Achha.
Call the next one. 29.
Should I appear for the petitioner? It has
Yes, please.
School Service Commission is the answering respondent, Millard.
School
we have-
Service Commission.
Yes.
Second SLST.
Millard,
What
where-
is the
where
issue?
10 candidates, Millard. We approached before your lordship, Millard, page 47 of
Tainted.
tainted list published. Millard, first list that was published, Millard, we have thrown challenges. Now, Millard, we became unsuccessful. Although, Millard, it was recorded in the Millard YouTube that your lordship was kind enough to grant leave, Millard, to challenge that first list. Millard, we filed a review application. This has not been gone down. Be that as it may, on 28th January 2026, SLST, Millard, has published a final list, Millard, incorporating our name on tainted candidate Weimar mismatch. Our specific case here is, Millard, we were neither interrogated by the CBI nor Millard witness nor charge sheeted. Number one. Weimar mismatch is a term, Millard, which is unknown to the judgment dated 3rd April 2025, as well as, Millard, the judgment passed.
Poretta din. Archana Shao. Yes.
Now, Millard, where, Millard, we had been working prior to 26 in SLRT with different government departments. 47 of the judgment, Millard, does not speak about that we are the categories, Millard, whereas we do not fall under the, Millard, the tainted categories. This 28th January 2026, we made a representation, Millard. Millard, nobody, Millard, lent their ears, Millard, to us, Millard, and Millard, it did not evoke any response from the School Service Commission. Why, Millard, we should be treated as tainted, Millard, which is contrary to the judgment of the Supreme Court, page 47, paragraph 47. We have annexed it, Millard. Millard, we are seeking repair. We have taken a categorical stand, Millard. We are not seeking any throwing any challenge to the second SLST. Number one. Number two, Millard, we are not candidates, Millard, we are not willing, Millard, page paragraph 23. Kindly seize, Millard, paragraph 23 of your lordship's speech. We have, Millard.
How many petitioners?
26.
26.
All court fees paid?
Paid দিয়েছেন court fees? মনে হয় না দেননি, নিশ্চয়ই দেননি।
Check up.
দ্বিধায় আছেন যখন দেননি। দিলে জানতেন। দিয়েছেন কি?
First pay the court fees and then I'll hear you.
Sorry, Millard, is it your lordship's pleasure, Millard, to take it up Friday, Millard, or Monday, any day?
Let us see.
Millard, we are facing a tremendous humiliation, Millard. We were, Millard, in the government department. We qualified ourselves, Millard. We are not tainted, Millard. At least, Millard, give some.
Not tainted? Your name is there in the tainted list?
We are not tainted under the judgment of the Supreme Court. We seek declaration from this honorable court, Millard.
All right.
Millard,
Declaration, the court will see you.
Millard, if the court fees are paid, Millard, by
paid
tomorrow.
Today itself? Paid today itself? I'll take it up.
Huh? আজকেই দেবেন?
If today it is paid prior to the আজকে দুটোর সময় কি হবে?
Fix another matter, Millard, tomorrow, Millard. So, Millard, if I pay it today, Millard.
All right, tomorrow.
I'm deeply pleased.
All right.
I'm sorry.
এই ম্যাটারটা
The next matter, what happened?
short matter?
Very short, because it is already done by my lord and senior my lord. Lordship, can you seize the order once, last order?
আচ্ছা দেখি 30.
The matter was about, my lord, I was not getting the post facto approval for my lord. Lordship, kindly seize, my lord. Post facto approval, my lord, for my lord, higher scale. So after the retirement, I am facing the problem. So, my lord, by the intervention of my lord and senior, my lord, I have been told that the post facto approval is granted now.
Make one hard copy. 2 o'clock.
Yes. 2 o'clock, my lord. Anyways, we are going to come and disturb your lordship at 2 p.m. matters.
No, that is all right. In a disturbance in a different matter and the matter is different. If you have it, then I can keep it on record and I can pass necessary order. 2 o'clock? এটাকে দুটোর সময় ডাকবেন তো?
Grateful, man.
All right. Which matter? 30? I'll not go to 31. I've got other matters fixed. All right.
My lord, please.
No chance to disturb the court again. Somebody else is appearing in the hearing matter. Yes, please.
Mr. Singh's representative has come from commissioner item number 28.
Yes.
At 2 p.m. then, ma'am.
First. Yes. Yours is 28
30.
and 28 গেছিল
We should.
but then 30. You got the hard copy?
Yes. Yes. না দাদা 30
আগে ওনারটা দিন
But the fact was, my lord, as I was just trying to point out to your lordship, is that previously, my lord, he was granted with higher scale of pay back in 1996, and my lord, the approval was not there. For which, my lord, he has retired from service in 31st of August 2021. But my lord, yet he did not get any pension, any gratuity, nothing. So, my lord, he came before this honorable court. After the intervention of this honorable court, the DI, my lord, has been, my lord, has issued this post facto approval. So, my lord,
please come.
My prayer before your lordship, so that my pension and gratuity, all unpaid arrears, my lord, should to be disbursed along with the interest.
Now school shall prepare the pension paper.
Yes, yes.
Send it to the DIO.
Yes. 31st August 2021.
The petitioner prays for grant of disbursal of terminal dues by taking into consideration his initial date of appointment. Stop. The service of the petitioner has not been approved.
No, my lord, the higher scale.
He said it was not approved subsequently.
Higher scale was not initially
কি বললাম?
approved. Yeah.
Disbursal dues taking into consideration his enhanced educational qualification.
My lord.
Stop. It appears that the approval of the petitioners, the enhanced qualification
Lordships.
was not granted. Stop. The school forwarded the prayer of the petitioner to the ADI of schools in the year 2022, seeking post facto approval of the PG scale of pay to the petitioner.
My lord.
Stop. PG scale of pay to the petitioner. Post facto approval. ঠিক আছে? Learned advocate representing the state respondents has obtained instruction from the ADI, Bonga subdivision, North 24 Parganas, signed on 18th of February 2026, which mentions that the postgraduate scale of pay has been sanctioned in favor of the petitioner with effect from 28th of September 1985 on acquiring his MSc degree in mathematics. Stop. Paragraph. As it appears that the respondent authorities have already sanctioned post facto approval to the postgraduate scale of pay of the petitioner, accordingly, the school is directed to make the necessary calculation and forward the same to the district inspector of schools for preparation of the pension file in favor of the petitioner. Stop. Paragraph. The respondent authorities shall take all efforts to ensure that the pension payment order, the pension file is made ready and forwarded to the DPPG within a period of 12 weeks from the date of communication of this order. Stop. PPO shall be issued in favor of the petitioner, and the money reflected in the PPO shall be disbursed latest within a period of 6 months from date disposed of.
But including the interest on the arrears.
দিতে গেলে তাহলে তিন মাস দিতে হবে কারণ ওখানে 3 মাস দিয়েছি from date.
Including the interest on the arrears, Malad. Because since 2021, I have not been paid.
You retired in?
Malad, 30th August 2021.
Acha, paragraph as the petitioner retired from service on 1st of August 2021, comma, the petitioner shall be paid the terminal dues along with simple interest
As your lordship.
At the rate of 6% per annum.
As your lordship.
Calculated on and from the date the same fell due till the date of actual payment.
Grateful.
Disposed. 28. What was 28?
That matter regarding 10 marks to be awarded, out of my experience in respect of the 10 marks,
Oh,
I'm entitled to. Page 71, we have made the representations.
Is commission aware of this matter? The experience possibly has not been reflected. Yes. I have dismissed.
Subject to correction. You lordship kindly.
All right, let appeal remain pending. Ashun dekhi. The petitioner prays for grant of marks on account of prior teaching experience. Stop. Petitioners. It appears that the petitioners did not disclose their educational qualification in the application form filed by them. Prayer has been made to direct the commission to consider their qualification and the period of service for awarding marks on account of prior teaching experience. Stop. Prayer of the petitioner is opposed by the commission. Stop. Reliance has been placed on the order dated such and such in such and such. Stop. It has also been brought to the notice of the court that mat number
2075 of 2025.
challenging the aforesaid order is pending consideration before the Honorable Division Bench. Stop. Will it be heard shortly or anything of that sort? The appeal?
I am instructed to submit that we have been directed to file our
Opposition.
file our application. So the updated file is not here.
All right, next. As it appears that the issue is pending consideration before the Honorable Division Bench, accordingly, hearing of the writ petition stands adjourned for the time being. Released for further consideration on 6th of April.
Yes. It is for the secondary, 9-10. Kindly mention this because in 9-10 I have not. That should be mentioned.
Marks of 9-10.
9-10.
ওই যে marks বলেনি in respect of classes 9 and 10.
One thing is one thing has to be kept in mind that here a person is approaching your lordship court on the 13th day of January 2026.
We have made the representation long back.
November. একটা line.
We have made the representation long back. They could have considered my case.
When we are unable to appear, one order of your lordship, Mokabar Hussain was carried in appeal on the ground of delay was your lordship was not pleased to entertain the petition. The appeal has been dismissed.
এই একটা লাইন লিখে নিন তো যে learned advocate representing the commission raises objection with regard to the maintainability of the writ petition on the ground of delay. ঠিক আছে? All right, next.
Deficit court fees as well as the affidavit of service.
Very well. Written with the records.
Grateful. দুজন
হ্যাঁ
My lord, 89, my lord, I am for the petition, it was continued.
Yes. I have tagged it together so that the issue can be decided
Yes,
in
my lord,
one
because
go. Otherwise, it
my
will
lord,
be a
Group D,
problem.
Group D expiry is under challenge. Right?
Show certain documents, yes. My lord, in these.
Maybe Group C and Group D, but the
Issue is
issue
same.
is same
Same.
whether the candidates appointed after
After
expiry of the panel is to be brought under the tainted list.
And my lord, 91 and 92 also the same issue.
Yes, that is the reason they have been tagged.
There are subject to corrections. There are applications, my lord, wherein we had to file affidavits. My lord, we had served the other sides. We had prepared the affidavits. My lord, these are not voluminous as was there in last occasion. May we file these affidavits, my lord. This is one of such affidavits.
By the candidates appointed after expiry of the panel?
Yes. We had taken out applications, my lord. Those are on record of your lordship.
And
15, 16.
have you all been implemented as parties?
Can 15, 16s are allowed?
My lord, there are 2 cans, my lord, which have not been allowed, my lord.
Yes.
I would request your lordship, my lord, all have been allowed every day. This will continue, my lord. I am only relying on up to
Opposition
whichever
of
can has been
the
allowed.
commission.
I will not give any reply. But my lord, kindly do not allow any further addition of party, my lord, otherwise it will continue. No,
Just wait. Please wait. Yes. Let the petitioner make submission.
We have given them the copies.
All right. Start.
My lord, on the last occasion, my lord, I was placing, my lord, I started from the order passed by the Honorable Supreme Court, my lord, paragraph 20 and paragraph, my lord, 31, which says, my lord, paragraph 20 affirms, my lord, the order passed by our division bench that after appointments given after expiry of panel, my lord, is illegal and they are considered to be tainted. And subsequently, my lord, paragraph 31 of the Supreme Court judgment says, my lord, that appointments which have been given for classes 9, 10 and 11, 12 after expiry of panel is illegal, and my lord, all the justifications that were made were not considered. Now, my lord, I also on that day, my lord, I placed the 2016 rules. Rule 15, my lord, I say the validity of the panel, it says it's 1 year from the date of publication of the list. And my lord, the commission did not have any power in terms of Rule 15 to extend the validity of the panel. Up to that, my lord, I submitted. Now, my lord, I would like to place the opposition of the commission. Commissioner opposition.
ওইটা দিয়ে বার করে রাখছি এই তো এখানে 9 জন
Yes.
My lord, straightway come to my lord, page 9. The lordship has come.
Page 9.
Page 9, my lord, under the heading counseling process for teaching staff for classes 9, 10.
Yes.
My lord, at the bottom. My lord, I am reading Roman 2. The panel for classes 9, 10 was published on 12th March 2018. My lord, kindly mark this date. The first phase of counseling could be started only on 6 September 2018. That is almost 6 months after publication of the panel. My lord, kindly note 6 September 2018 in their opposition. They are saying the date of the first counseling. My lord, thereafter, Roman 3. The delay in appointment was caused by an order dated 11th November 2016, which was passed in Swanso, wherein the validity of Rule 8.4 of 2016 rules was under challenge by some contractual teachers who were desirous of participating in the 2016 selection process for classes 11-12. My lord, this is for 11-12, not for 9-10. For 11-12, the Honorable Single Judge of this Honorable Court on 11th November 2016 directed the School Service Commission not to issue any recommendation for appointment and not to grant any appointment without prior leave of this Honorable Court. My lord, here I stop here for a moment. My lord, I accept what has been stated. The order is annexed. I am not disputing. The order is do not issue any recommendation without leave of the court. There was no bar, my lord, on conducting the counseling process. And secondly, my lord, this order relates to classes 11, 12, not 9, 10. My lord, thereafter, appointment without leave of the court. In WP number so and so, although the recommendation process was stayed for the candidates for classes 11, 12, since a large number of candidates were common for both group classes 9, 10, and 11, 12, and the underlying issue was analogous for both the selection process, the counseling process could not be started for classes 9, 10 as well. My lord, here, my lord, this is absolutely a, my lord, wrong statement. Why? Firstly, there was no stay on recommendation. Thirdly, my lord, the panel of classes 9, 10 and 11, 12 were published on different dates. So 11, 12, even if there is a stay on the process of issuing recommendation without leave of the court, it has no bearing, my lord, on the counseling process of classes 9, 10. Thereafter, my lord, Roman 4 at page 11. The order dated 11th November 2016, that is, my lord, the earlier order, could be modified on 25th of July 2018, when the commission was granted liberty by this honorable court to recommend for appointment and grant appointment to all successful candidates of the 2016 selection process by keeping the exact number of seats vacant as the writ petitioners in the 4 writ petitions. Thereafter, my lord, page 12, Roman 5. Despite the modification of the order dated 11th November 2016, on 25th of July 2018, the first phase of counseling for the subject Bengali could not be conducted due to a direction issued in so and so, by which the operation of the vacancy list in the subject of Bengali was stayed as an interim measure, as an interim order was passed, thereby restraining the commission from completing the selection process in respect of 86 vacancies. My lord, this was only in respect of subject Bengali, that too for 11, 12 in respect of 86 vacancies, not the entire thing, my lord. Thereafter, my lord, page 13, Roman 7. Kindly see, my lord, the ground taken. It is stated that after the conclusion of the first phase of counseling, the second phase of counseling was delayed due to a major law and order issue arising out of the vacancy problem. It could be conducted on 5th February 2019. My lord, and law and order issue, they are the state authorities and they are not cannot control it, and they are taking a ground that because of law and order issue, counseling could not be conducted, my lord. Kindly see the steps of the grounds of the commission. Thereafter, my lord, it is stated that notice for third phase of counseling was published on 8th March 2019, and the counseling took place on 26th March 2019. My lord, admittedly, as your lordship has seen, the list was published on 12th of March 2018. And my lord, the third phase counseling was conducted on 26th of March 2019. So, my lord, it is an admission that third phase of counseling onwards was after the expiry of the panel. My lord, again, paragraph 9, it is stated that fourth phase of counseling we started on 20th September 2019, page 14. The fourth phase of counseling was delayed due to model code of conduct imposed in line of the 2019 parliamentary elections. My lord, your lordship knows, my lord, a process which was started way before the parliamentary election and it was continuing, my lord. The model code of conduct is not a bar in continuing with that process, my lord. I need not to, my lord, show, my lord, any side judgments, my lord. Your lordship knows better, my lord. This is not applicable. This is the ground they have taken. My lord, then Roman 10. Kindly see, in view of the inevitable delay caused in initiating the counseling process due to the orders passed by this honorable court, as well as the administrative delay, the commission fixed the date of expiration of panel for classes 9, 10 to be on 19th December 2019, that is exactly 1 year after the counseling of subject Bengali could begin. Here, my lord, I will again fall back to the 2016 rules once. 2016 rules. এখানে আছে না, এইখানে, মানে 2016 rules, I have given your lordship a copy.
Yes.
মানে 2016 rules, rule 15 দেওয়া আছে, মানে rule 15, validity of the panel. My lord, once again I am placing each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or the date of advertisement for the next selection process, whichever is earlier. Here, my lord, it should be from the day 1 year from the date of publication of the panel. Now, my lord, Roman 2 and provided that the names of candidates shall not be recommended against any post other than the post applied for, my lord, not applicable. 2, notwithstanding anything contained in subsection 1, a panel, waiting list, merit list prepared by each of the regional commission before coming into force of these rules, such panel, waiting list, merit list shall remain valid according to the rules prevailing. So, my lord, this is also not applicable. So, my lord, rule 15 does not provide any power to the commission to extend the validity of the panel. My lord, rule is very specific. It is 1 year from the date of publication of the panel. So, my lord, whatever has been stated in paragraph 10 that the panel has been extended up to 19th December 2019 is absolutely bad in law. And, my lord, the panel was published on 12th of March 2018. Thereafter, my lord, kindly come to 11. It is stated that even after the 7th phase of counseling in the 2016 selection process, kindly read this, man, interesting, a large number of vacancies were unfilled due to abstentionism of selected candidates and non-joining. On the other hand, a large number of candidates on the waiting list were making representations for their appointments. Since the commission was prevented from holding further rounds of counseling, which would have been sufficient for filling up of all the vacancies by various legal and administrative exigencies for which none of the candidates could have been faulted, the commission decided to hold another round of counseling for filling up the remaining vacancies in the interest of schools of West Bengal and for the benefit of students. Here, my lord, the Article 12 authority is deciding to give appointments on the basis of the representations of the waitlisted candidates after expiry of the panel. My lord, where are those representations annexed? Those have been made. We all know, my lord, what happened in those agitations and those representations. And, my lord, our division bench has hold that during those agitations and representation, a so-called super committee was formed with the then education minister, and all these everything happened, my lord, every corruption and everything, and this is part of the record, and this has been upheld by our division bench as well as the Supreme Court. And, my lord, paragraph 12, Roman 12, the 8th phase of counseling was envisaged to be conducted during March, April of 2020. My lord, kindly see this statement. You all know what happened, my lord, in March and April 2020, the COVID. But the same was further delayed due to the nationwide lockdown imposed by the government of India in view of so and so, my lord. After the lockdown conditions were somewhat relaxed by the government of India, the 8th phase of counseling was conducted. It is stated that during the 8th phase of counseling, the candidates were recommended by the commission strictly based on their merit through a transparent process of counseling. The recommendations were made strictly in terms of the ranks of recommended candidate in the select list. My lord, this is absolutely uncalled for and bad in law. Then thereafter, my Roman 13. After the conclusion of the 8th counseling by the commission, it was discovered that around 102 vacancies were lying vacant for classes 9-10. Several waitlisted candidates approached the Honorable High Court seeking appointment to those vacancies. On 14th December 2022, the Honorable Single Bench of this Honorable Court, while considering a batch of writ petition, including so and so, my lord, noted that about 102 posts of classes 9-10 notified in 2016 selection process were vacant due to non-joining of rank jumpers. The Honorable Single Bench thus directed the Commission to hold counselling in those 102 vacant posts and recommend candidates in terms of their inter se merit and position in the select list of first SLST. My lord, if your lordship kindly remembers, paragraph 31 of the Supreme Court judgment, take note of all these orders, says that in stray cases of rank jumping, the court passed an order of recommendation after expiry. At that point of time, it was not within the knowledge that corruption was at large, and so those orders cannot be taken as a defense. So, my lord, the Supreme Court has even directed that the orders which were passed by the High Court after expiry are also bad. My lord, thereafter, they have stated in paragraph page 17, Roman 15. Additionally, on 30th August 2022, these Honorable Court directed the Commission to appoint 2 candidates who were called upon to attend 8th counselling, but they could not attend the 8th counselling for alleged lack of proper information. My lord, these are all after expiry. I am not repeating, my lord. They are just giving the reason why, but they are not at all sustainable. My lord, now Roman 17 at page 18. Roman 17. It may be also mentioned that even the first 7 phases of counselings were conducted through a proper and transparent process with due notification and public counselling system, which was in the knowledge of all concerned stakeholders. There was no compromise with merit except those who had mismatch OMRs, and none of these so-called post-expiry candidates can be called to be tainted, nor were they featured in any of the lists submitted by CBI after a thorough investigation. Here, my lord, what is tainted, my lord? A process is said to be tainted if something is corrupt. My lord, a selection process, if selection process is found to be illegal, the appointment made through that illegal process becomes corrupted. My lord, appointments given after expiry of panel is an illegal process which has been in paragraph 31 of the Supreme Court has declared, my lord. Now, any appointment through that illegal process, my lord, is a tainted process. And that is why, my lord, appointments are tainted. And that is why, my lord, the division bench in just Boishakhi Bhattacharya Supra, my lord, has stated that who are going to refund their salaries. It has been specifically stated in that, my lord, persons who have been appointed after expiry of the panel are the persons who are going to refund their salaries. And that portion, my lord, who are going to refund their salaries, the Supreme Court has tainted those persons, termed those persons as tainted and has affirmed that portion, which I will place a little later on. My lord, thereafter, it's counseling for 11 and 12, my lord. Page number 19. Page number 19, my lord. The panel for classes 11-12 was published on 27th November 2017. However, the counseling process could not commence till the end of July 2018 due to substance of a stay order dated 11th November 2016, which was passed by this Honorable Court in Swanso. My lord, kindly your lordship remember, while in 9-10 an order was placed. It was talking, this paragraph talks about that order, my lord. Kindly mark the date. It is on oath, my lord. They have stated that it is in July, not before July. The counseling process was not started. Thereafter, my lord, next. It is stated that the second phase of counseling was subsequently held on 29th of August 2018. The third phase of counseling was delayed due to a major law and order issue. My lord, these are all common grounds that have been taken, although I will show from their affidavit the date of publication of the panel and the counseling process for 9, 10, 11, 12 are quite different, and there was a substantial time gap, my lord, between those two counselings, but the point they have taken are all same, my lord. Thereafter, my lord, Roman 20 at page 20. it is stated that after the initial counseling, 3 teachers were recommended by the commission for appointment to the so-and-so high school, Uttar Dinesh, but on 20th September 2018, the students of the school started agitation against the appointment, and the protest against the appointment turned violent, resulting in the death of 2 persons. It is stated that on 22nd September 2018, the commission submitted a report to the Honorable Minister in charge, Government of West Bengal, regarding the appointment. Then certain curative steps were taken to avoid such an unfortunate incident. This was an administrative issue that was also contributed to the delay from September 2018 to February 2019. My lord, commission is an autonomous body, statutory body. They are, the 1997 Act has given them power to conduct a selection process, issue recommendation. My lord, they are under law, my lord, they are not bound to report to the Minister of Education that I have given a recommendation, appointment has given, students are agitating, so we are recalling back the appointment, so other counselings could not be done. My lord, this is unheard of. This shows the malice, my lord, the malafide of the commission in conducting the selection process, because all these counselings in between, after expiry, all this counseling has been made, my lord, just to accommodate those candidates who have Weimar mismatch or rank jumping, or my lord, out of panel, those candidates, and my lord, for other considerations. My lord, Roman 21, it is stated that 4th phase of counseling took place in September 2019. So my lord, 3rd phase, 4th phase admitted after the date of publication of the panel, and the delay caused in it was partly administrative and partly due to the model code of conduct imposed in the light of 2019 parliamentary. All at the same ground, my lord. The 5th and 6th phase counseling were held on 11th November 2019 and 19th November 2019. So my lord, admittedly, these were all after expiry, and the ground administrative inconvenience and my lord, election. My lord, may I put this question to myself? My lord, commission was so, if the action of the commission was so bona fide, what stopped them from approaching the school education department or this honorable court? See, these are the problems, the panel may kindly be extended for the benefit of the students and teachers. They did not, my lord, because the rule did not permit them to do so. My lord, now your lordship has noted the date of publication of the panel and the 1st phase, 2nd phase counseling. Now, my lord, kindly come to their annexure, my lord, at R8 at page, my lord, 94 of their opposition.
Page
94.
94.
My lord, this is 11-12. This is the notification of the West Bengal School Service Commission for 11 and 12.
Yes.
My lord, kindly see date at serial number 9, date of publication of final panel. 27/11/2017. Now, my lord, from
this is in respect of classes 9 and 10.
11-12, my lord.
11-12, where do I get it?
My
Is
lord,
it mentioned?
Here, my lord, but it is not.
All right,
my
11.
lord, but where from it is getting, my lord? Kindly see, my lord, 2, serial number 2. From the total vacancies, it can be ascertained that it is for 11-12. My lord, date of publication of panel, my lord, kindly note 27/11/2017. So, my lord, expiry is 27th November 2018. During this period, my lord, there was no model code of conduct, there was no parliamentary elections, nothing. All this happened after the expiry.
Yes.
Now, my lord, kindly see date of first counseling 16/7/2018 to 22nd July 2018. My lord, I say this is absolutely right, because your lordship now fall back to the date of counseling which the commission has stated in their opposition. My lord, that is at page or 11-12, that is that page, my lord.
All right, there is no issue with the first phase and the second phase.
No, my lord. Why I am saying, they have stated, they have talked about an order that 25th July order, the order was, stay order was lifted on 25th of July 2018, that you can issue letter of recommendation. Only after that order, the counseling was started. That point was taken, my lord. Now, kindly see the date of first counseling, 16th to 22nd of July. Admittedly, on 25th July, the stay order was lifted, but what was the stay order? You will not issue any recommendation. There was no stay order on going through with the process of counseling. That is why, my lord, first and second phase counseling started even before that stay order was lifted, which is their contrary statement, which has been stated in their opposition, my lord. So, my lord, admittedly, they have started the counseling process before the stay order was lifted. That is why we wanted to.
All right.
And my lord, kindly see the second phase. Date of second counseling 29/8/2018. And kindly see date of third counseling 19/3/2019. My lord, what prevented them from the date of second phase of counseling to wait after so many months for the third phase? Because during this period, my lord, there was no model code of conduct, there was nothing. Well, the reason they took that there was agitation, there was law and order problem, and there are an Article 12 authority, there are state authorities. That means they are saying that the administrative machinery has failed, we cannot work. My lord, kindly see status of panel expired. Now, my lord, kindly come to page 95. This is for 910. My lord, your lordship will get that 910 from the total vacancy 12,905 at serial number 2.
Yes.
Now, my lord, serial number 9. Date of publication of final panel 12th of March 2018. Now, my lord, kindly see the time gap between the 910 publication of the panel and 1112 publication of the panel. One of the points, my lord, taken by the commission that there are several candidates of 910 and 1112 who are both listed in the same 910 as well as 11. Well, once 1112 panel was published first. So once a candidate's name is there in 1112, how could the commission say that he or she may also appear in the list of 910 when the list of 910 has not even seen the light of the day? So, my lord, the point taken that there was a stay in 1112, so we could not proceed with the 910 counseling is absolutely, my lord, false and misconstrued, my lord. It's a false statement to mislead this honorable court, my lord. Now, my lord, kindly see the date of first counseling, 12/3/2018. Panel published on 12/3/2018. Date of first counseling, 12/3/2018. Your lordship has got that?
Yes.
Now, my lord, one interesting thing I'd like to show, my lord. Kindly come to page 9 of the opposition. 10 of the opposition. It's a purely false statement, my lord, which has been made on oath. Kindly see. Only on 6 September 2018, that is almost 6 months after the publication of the panel, the first counseling started. And my lord,
1 minute. Page 10, you say?
My lord, page 9.
Oh,
My lord, I am reading. The panel for 910 was published on 12th of March 2018. My lord, now kindly compare this with page 95, 12th March 2018. Now, my lord, the first phase of counseling could be started only on 6th September 2018. Kindly see the date. And now, my lord, page 95.
All right.
See, my lord, completely false statement. Even the second phase, all dates are wrong, my lord. Now, my lord, 5/2/2019. Kindly see, my lord, 12/3/2018, first phase of counseling. In 2018, no, my lord, model code of conduct, no stay order, nothing on counseling. After almost 1 year, this second phase of counseling started. Why, my lord? They are only saying law and order issue. My lord, I do not have to repeat myself, my lord. Now, my lord, kindly fall to serial number 21, status of panel. Expired on 18/12/2019. My lord, commission has no power to extend the panel, my lord, beyond 1 year. They are bound by the rules. Rules does not give them any power to do so. My lord, thereafter it is for group C, group D, I am not. And my lord, It is these documents they have annexed as R8 in this opposition, my lord. Now, my lord, basically, the points which have been, firstly, it has been an admission on their part that after for classes 9, 10 and 11, 12, both for classes 9, 10 and 11, 12, after second phase of counseling, all counselings were after the expiry. And the reasons they have stated, my lord, not a single reason is tenable. My lord, why? Model code of conduct not applicable, law and order, it is not an administrative machinery failure, then it has to be stated that it is a failure of administrative machinery. Second, commission, if commission is so bona fide in their action, they could have approached the school education department because the rules have been framed by the school education department. They could have relaxed it, or they could have approached this honorable court to kindly extend the validity. We could not. These are the reasons they do not. And apart from all this, my lord, all these everything were argued and placed before the Honorable Supreme Court, and that is why in paragraph 31, it has been specifically stated that has tried to justify the extension of the validity of the panel. I will not repeat that, your lordship remembers. Now, my lord, kindly come to division bench judgment of Boishaki Bhattacharya, my lord, that thicker paragraph 363 ta bar korbo. My lord, Roman 4 I will place at page 272 of the judgment. My lord, Roman 4. Persons who had been appointed outside the panel after expiry of the panel, and also those who submitted blank membership but obtained appointments must return all remunerations and benefit received by them to the state exchequer along with interest calculated at 12%. My lord, the division bench was very conscious about this, and the division bench, there are 17 types of illegalities in paragraph 335. The division bench, my lord, could have said all those 17 illegalities who have got the benefit are entitled to refund their salary. But my lord, division bench was very conscious and only stated 3 categories of persons: outside panel, expiry of panel, and blank OMR. Not only, my lord, the OMR could have been OMR mismatch, but there are 2 categories of OMR mismatch, my lord. One who have got 10 given 53, another is submitted blank given 53. The division bench was categorical, only blank OMR after expiry and out of panel will refund their salary because they are found to be tainted. And how, my lord, this paragraph had been dealt with by the Honorable Supreme Court. My lord, paragraph 45, and this is at our writ petition, page 67.
3rd April's order? 3rd April's order?
Yes, 3rd April's order.
All right.
My lord, page 67 of my writ petition.
Paragraph 45.
45.
Yes.
The lordship has got that?
Yes.
My lord, I am reading. The last question relates to the relief and whether it requires any modification. We find no valid ground or reasons to interfere with the direction of the High Court that the service of tainted candidates where appointed must be terminated and they should be required to refund any salaries or the payments received. Since their appointments were result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. My lord, this relates to Roman 4 of paragraph 363. My lord, this says that those appointments were found to be fraud and tainted. We find no justification to interfere and they should refund their salaries. So, my lord, in effect, 363 Roman 4 has been upheld by the Honorable Supreme Court, saying that after expiry of panel is a tainted candidate. And my lord, the Honorable Supreme Court in this way has in fact given a list who are the tainted candidates. Those are the tainted candidates who will refund their salary, and my lord, we will not be able to sit in the examinations and everything. So in effect, my lord, Supreme Court has clarified, my lord, categorized who are the tainted candidates. Now, my lord, I have already placed the judgment of another division bench of our High Court in Sanjay Dori, presided over by Justice Shoumen Sen, my lord, where, my lord, in paragraph 32, My lord, your lordship remembers, that division bench has also categorically noted that after expiry of panel is a tainted candidate. My lord, I have given that judgment. এখানে দেখো বার করা আছে।
Is Sanjoy Doloi in the compilation? Not in
I
this
have given that.
All right. Where?
Matter I've annexed that.
No,
I
I'll get jumbled. It's
No, no, I
from
have
your
given
brief.
that.
From you've handed over copy?
My lord, I have another copy, my lord.
Wait. Please wait. Yes, Sanjoy Doloi, 10th July is here.
My lord, paragraph 32. Paragraph 32 at page 23. Paragraph 363, Roman 4 has classified 3 categories of candidates who can be described as tainted candidates. Persons who have been tainted outside the panel, persons tainted after expiry of the panel, and persons who have submitted blank OMR sheets to obtain appointments. Now, my lord, what was this appeal for? My lord, this petitioner, my lord, filed a petition before the single bench saying that tainted candidates are being allowed to participate in the 2025 recruitment process. The single bench, my lord, declared that no tainted candidates would be allowed to participate. From this, my lord, interestingly, state and commission preferred an appeal saying that no, tainted candidates must be allowed to participate. My lord, now what is the direction? Your lordship has seen paragraph 32. Now, my lord, what is the direction? My lord, paragraph 33, my lord, kindly come to paragraph 33 once. It is really shocking and baffling that the appellants are supporting the tainted candidates. None of the 3 categories of the candidates mentioned in the orders of the Honorable Division Bench and the Honorable Supreme Court deserve any consideration. The argument that these candidates should have a level playing field on the basis of Article 16 of the Constitution of India is clearly not acceptable, as it would mitigate against the basic notion of justice and fairness. It cannot be the fundamental policy of the state to encourage fraudsters in public employment. They have no place in the system. If someone gets any job by way of cheating, then such appointment tantamounts to be a fraudulent and illegal, and he cannot be permitted to participate in the selection process initiated for filling up the vacancy which had resulted due to his unlawful and illegal action. The judgment of the division bench as well as the Honorable Supreme Court could show that the board has admitted the guilt and the entire selection process was set aside as it was vitiated by reason of fraud and collusion of tainted candidates with the members of the board and other agencies. My lord, kindly these observations, these were not challenged before the Supreme Court, my lord. Now, my lord, kindly come to paragraph page 28 at paragraph 40. The decision, my lord.
Yes.
In view thereof, we are not allowing any applications to be filled by the tainted candidates for the recruitment process initiated pursuant to the order of the Honorable Supreme Court. So, my lord, there is a specific order. Paragraph 40 has to be read with paragraph 32, my lord. It has to be read as a whole, not in isolation. Paragraph 40 is a result of paragraph 32, which says that these 3 categories of candidates will not be allowed to sit in this 2025 recruitment process. Even after this order, my lord, the commission has allowed every candidate to sit for the selection process. Now, my lord, a point has been taken. Now, as far as, before coming to that, as far as state's replies, opposition is concerned, I say, my lord, state is not a party, my lord, not a necessary party in this litigation, though they have been made parties and they have filed their opposition. Why? My lord, this relates to the conducting of the selection process based on the rules. This writ petition does not relate to interpretation of the rules or challenge to the rules. State has only framed the rules. It is the commission under the 1997 Act that has to abide by the rules and act in accordance with the rules. So, whether the appointments were given after expiry, whether appointments where panel has been expired or not. These are the things to be answered by the commission, they being the recruiting authority. State is not the recruiting authority, my lord. So, my lord, though the points, grounds are absolutely same, my lord, I am not going to, I will rely whatever submission I made in in commission's opposition, my reply would be same. Only addition, my lord, state is not a necessary party here, because state has also in their opposition has said that all these are information derived from the records, not true to their knowledge. And what is not true to their knowledge, information derived from the records, that cannot, they not being a necessary party, not being the recruiting authority, they cannot say whether these candidates have been appointed after expiry or within the expiry. Now, my lord, a point has been taken. What is, the appointments may be illegal, but the appointments are not tainted. That, my lord, I have already shown from the Supreme Court judgment that these appointments have been termed as illegal as well as tainted. But for, if you're, my lord, only once, my lord, what is tainted? It is not. My lord, this is, kindly see, my lord, from Black's Law Dictionary. I will not place tainted. What is the meaning of tainted? Corrupt. Second. My lord, the second one, kindly see the tainted, the second one. My lord, it tainted, any taint process which is tainted cannot stand alone unless and until that is illegal, one cannot be tainted, my lord. And my lord, the Honorable Supreme Court in paragraph 45 had categorically stated that persons who have been directed to refund their salaries are all tainted. And paragraph 363(4) says what the persons who are termed as tainted and who are going to refund their salaries. Now, my lord, only as far as the opposition of the private respondents, my lord, I say, my lord, though they have been added as respondents, my lord, I say they cannot have any say, because whether their appointments are they have been given appointment after expiry or not are to be answered by the commission. They are the candidates. They cannot say what caused delay and everything, my lord. It is the commission who is going to explain, my lord, whether their appointment is within expiry or after expiry. So, my lord, if their appointments are after expiry, they are absolutely bad in law and they are not permitted to, they cannot be permitted to sit for this instant recruitment process, my lord. And my lord, I am not giving any reply to the affidavits of the private respondents, and my whatever I have submitted in commission, my reply will be same. Another point, my lord, it has been stated that CBI has not said that these are tainted or not. My lord, it has not been placed. If it is so placed that CBI charge sheet does not say so, I will, in reply, I will say that CBI says that they have investigated after expiry. But, my lord, the number of candidates may vary, because CBI has processed, my lord, on the basis of the expiry list, date of expiration, which have been provided to them by the commission. Because my lord, CBI is not somebody to say when the panel has expired. The commission has given the date, suppose after 2 years, they will take that date as the after expiry date and they will proceed. Even taking that date, CBI has come to a conclusion that it has expired, appointments have been given after expiry. But be that as it may, but even if CBI has not filed any charge sheet, had not said anything after expiry, my lord, it cannot be said that because of that, expiry of panel or candidates who have been appointed after expiry cannot be said to be tainted or illegal, my lord. Because if the law is something, and if something is done contrary to that law, my lord, that is illegal. Now, my lord, only I would like to place two judgments of the Supreme Court in this regard. First is, my lord, 1996, 2 SCC, page 7. My lord, paragraph 6. 1996, 2 SCC, 7. My lord, paragraph 6. My lord, may I read?
Yes.
From the aforementioned fact, it is clear that the selection committee had prepared the panel or list on 19/1/1991. The first batch of 98 appointments were made therefrom. The reservation rules were then modified. The second batch, as per the said modified rules, was sent later on 5/6/1991. But the panel was one prepared on 19/1/1991. Rules provide appointments and professional rules so and so. Every teacher will be appointed on probation for 2 years. The list of candidates prepared for direct appointment will be valid for 1 year from the date of approval of the project by the selection committee. It is also 1 year. The life or duration of the panel or list was therefore for 1 year of 1 year. It therefore expired on 18/1/1992 by force of the above quoted rule. The rules having been framed under Article 309 of the Constitution therefore had statutory force. Here, my lord, the 2016 rules have been framed in terms of the 1997 Act. Statutory force. The appellant state was therefore right in contending that continuance of the panel or list beyond 1 year would be a violation of the statutory rule and therefore illegal. Even the court could not stop it from lapsing it in exercise of judicial discretion unless its constitutional validity was. My lord, here the Supreme Court is saying even the court cannot extend the validity of the panel. Here, my lord, this is what I would like to present. Another judgment, my lord, 2010 টাকা। My lord, 2010 6 SCC 777. My lord, paragraph 22. Paragraph 22. My lord, there are several judgments. Only I am placing these judgments. So this is the, my lord, view which has been taken by the Supreme Court consistently, my lord. Paragraph 22, my lord. The tribunal, after recording the finding of fact that the life of select list had expired, held that as the selection could not be held in subsequent years, thus the candidates whose names appeared in the panel should be offered appointment by granting relaxation of the rules. Issuance of such a direction is not permissible in law, as no appointment can be made from the panel after expiry of the life of the select list. But I am not placing the other paragraphs. So, my lord, if I sum up my argument, my lord, it says, my lord, whatever may be the reason for not conducting counseling within the validity of the panel, any counseling conducted after the validity of the panel, my lord, is bad, and subsequent to that counseling, any recommendation appointments are also bad. This is my first. And there is no justification given by the commission which is sustainable that what prevented them from conducting the counseling. I have also shown from their opposition, they have intentionally, my lord, tried to mislead this court by giving wrong dates to this honorable court, my lord, of the date of counselings. And my lord, what point they have taken that because of pendency of a matter, counseling could not be conducted is also a false statement, because their document shows that counseling has in fact was conducted. And my lord, and my lord, whatever has been argued here has been argued before the Honorable Supreme Court, and after considering everything, the Supreme Court has declared this illegal. And as my lord, illegal and tainted, I have already submitted. Now, my lord, in paragraph, I must say this, my lord, in paragraph 31 of the Supreme Court judgment, there is one paragraph that in stray cases, High Court has given appointment. My lord, High Court cannot even give an appointment after expiry, but those appointments which have been given by the High Court, my lord, those persons are the victims of corruption, my lord. Those appointments, my lord, cannot be termed to be illegal and tainted because they were the victims of corruption. They approached the High Court. See, we have the victims. There are vacancies. Give us appointment. High Court erroneously, my lord, directed appointment, which the Supreme Court says even the High Court cannot. So, my lord, those appointments which are given by order of the High Court, that there are vacancies, you give appointment, those may not be termed as tainted and illegal. These are my submissions, my lord, with regard to expiry of panel. Only one thing, I reply to the commission. Only one thing I would like to show, my lord. My reply to the commission. reply to the commission is 13th of January.
Yes.
My lord, only page 8. My lord, why I am showing this? This is the notification for publication of the panel. This is for 11/12, my lord. Kindly mark the date. This is the publication. And my lord, next page 10 is for 9/10. Page 10 for 9/10. My lord, I say all these candidates who have been appointed for 19 and 11/12 after expiry of panel should be, my lord, bird. They have already participated. They are in the select list in 11/12 and 9/10 verification not started. They are the candidates who should not be allowed to participate in terms of, my lord, 2 division bench judgment as well as of the Honorable Supreme Court and the 2016 rules. These are my submissions. And my lord, I adopt all these submissions, my lord, in respect of the oppositions which have been filed by the private respondents. Another submission was, since I have completed, my lord, your lordship may not be kind, allow, my lord, any further addition of party after 20, because I do not know what else they will declare.
All these have been placed in respect of Probir Midda.
Probir Midda.
All right.
Well, I have not completed.
This matter, I appear for the respondent. My application for addition of party was allowed, and I have responded to his application, petition. Milord, he has chosen, Milord, not to respond to my affidavit for the simple reason, Milord. He has taken a consistent stand, Milord, saying that my appointment, Milord, that was granted, Milord, as a sequel to the order, Milord, passed by this honorable court should not be treated as tainted. Number 1. Number 2, Milord.
Were you appointed in that matter, Setabuddin?
Tamburi.
Setabuddin matter, which there is an order to appoint 102 candidates. Are you in that list?
No.
My lord, I tell you there are 2 persons. One is 102. Another order they have talked about, my lord, subsequently, not in 102, subsequently another by another order, appointment was directed to
how many candidates?
1 candidate, and 102 and 1.
And your
That
lordship
means
also
103 candidates.
And my lord also kind enough, Milord, so far as my candidature is concerned, Milord. First, Milord, I got appointment, Milord, in an application for addition of party, Milord. His Lordship Justice Gangopadhyay was kind enough to direct the commission, Milord, to grant recommendation, Milord. As a sequel thereto, Milord, I was appointed. Number 1. Milord, an intra-court appeal was preferred by the commission. The division bench presided over by Justice Shane, Milord, affirmed the order passed by Justice Gangopadhyay, Milord, as his Lordship then was, and the commission, Milord, did not prefer any appeal before the Honorable Supreme Court. So, Milord, that order binds. Milord, I have been working there. Now, Milord, the Honorable Supreme, the Mr. Dashgupta, Milord, has said, Milord, the last occasion also, Milord, so far as I am concerned, Milord, this sole candidate, solitary instance, Milord, my appointment has not been questioned. If that is the submission, Milord, so whether, Milord, I am entitled or correct in saying, Milord, that by reason of such submission, since, Milord, he has just few minutes ago, Milord, he has also submitted, whether, Milord, my name can be expunged from the proceedings, since, Milord, the petitioner is not making any allegation, Milord, with regard to the mode of appointment.
But then it is you who filed application for addition of party.
Because,
The
Milord,
petitioner has not added you.
Milord,
The
no,
petitioner did
because,
not.
Milord, Milord, an impression was given to me, Milord, I was given to understand, Milord, the persons, Milord, were favored with the court's order, Milord. That is also a subject matter of a judicial scrutiny. So, Milord, my apprehension at that point of time, Milord, had it been a case, Milord.
What is the name of your client and the application number?
Milord, can 1 to? Can 1. And can 6, Milord, Mr. Ujjwal Rai, Milord, his application.
So it's similarly standing.
Can 1 and can 6.
Can 1 and
1 and
1 and 5?
1 and 5.
Can 1 and can 5. Ekটু দেখি না, please.
And in this
you both these set of candidates were appointed pursuant to order passed by
this
court.
honorable court, inter-court appeal preferred, Milord, the division bench affirmed the direction, and not only that, Milord,
the commission did not prefer any appeal against this order. So, my lord, commission accepted the order. So today, my lord, yes. So today, my lord, there is no point in pursuing the litigation, my lord, against my client.
It is you who got yourself
No, I
inflicted.
got myself, my lord, including because, my lord, because his submission was to the extent, my lord, that, my lord, but I tell your lordship, on the first day, my lord, Mr. Dashgupta, my lord, has made it clear. Even then, my lord, since on that day, my lord, your lordship said that, let me hear this.
Yes, let's
Yes.
make up
So,
my
my lord,
mind until I get to know the facts of the case. I couldn't
yes.
decide.
Now, my lord, your lordship, in a different matter, writ petition filed by my client, directed the commission, my lord, in view of the other three orders, my lord, to consider my case. The commission has considered my case, my lord, so far as the experience marks is concerned.
That is different.
That is different. So today, my lord, no, আমি জজ সাহেবকে বলছি. So, my lord, if your lordship records his submission, my lord, and my lord, expunge my name so that I can.
His recording will not do. Now he has placed his case. The case is here before the court. I have to hear all the parties and then take a call. Right? Only by relying on what he submits, it cannot be done.
Permit me to file my, then my lord, let me submit on the next day, my lord, so that I can argue, my lord, if your lordship wants to hear, my lord, I can deal with his submission. Since, my lord, his principal submission, my lord, is this, my lord, that he is not placing anything against me, my lord. So even then, my lord, in vacuum, my lord, I will try to, my lord, read for my lord's kind consideration, my lord. My lord, it is not a knee-jerk reaction, but still then, my lord, I need to, my lord, go through some.
Yes, please do.
Yes, my lord.
এটাতে কতগুলো party আছে?
Oh,
Can five? How
and
many applicants are there?
Can five?
Quite a few.
Can five?
But let us complete from our side, then we'll let the private respondent.
Our side means?
The two more matters are there. 91, 92.
Yes, I'll hear just now. This is in connection with Probir Midda. That is the reason.
11 director.
31 applicants.
Yes, ma'am.
All appointed.
I just take your lordship. May I just see this name, the first name of the applicant?
First name is Saddam Hussein.
Yes, that one.
A very famous name.
May I take my lord's kind leave? I'm leaving you.
Yes. All of them have been engaged by the order of this honorable court.
By orders of court. All right. And you've annexed the orders?
Yes, yes.
All right. The petitioner in the other matters?
I am for the petitioner in the other two matters.
Right now, no further. Enough time has been granted. Now you must be following. Maybe, but then possibly the arguments will be the same. Not some. I can say it will have huge impact. Not some. Because the Supreme Court's order is there and it is continuing. Yes, I understand. I will hear you. Irrespective of the fact whether you are added as parties or not, the court will hear you. This much I can say. Because you will make submission apropos what the petitioners have submitted. Yes, so if one is added, make submission. All right, so all your points are covered over there. So I'll hear you. Do not worry.
I will reiterate my dear that kindly bear in mind that there are also about how much
the number of candidates is not very important. The issue, the point raised. So many candidates involved. So the impact will be huge. Whether it is this way or that way is different, but it is going to have an impact. Certainly,
Whatever is the decision finally your lordship.
certainly.
We are here to act that will. The outcome we have no control.
I will look forward for your assistance. This much I can tell you.
91 hours. Open up.
1 minute, please wait. 90, who is the petitioner? So 89 petitioner submission is over. All right. 89 একটা order record করুন তো। এগুলো কি একসাথে হচ্ছে কি? But with order কি with করে আছে? That is all right. কিন্তু orders individually pass হচ্ছে। তো প্রবীর মিত্তাতে লিখে নিন যে learned advocate representing the petitioners concludes argument.
Our oppositions to
91 হচ্ছে Rajiv.
So the petitioners conclude argument in item number 89.
Yes,
I'll
89.
hear the respondent.
I have filed a CAN application,
In
21, in
in
item number 89, supporting the stand of the writ petitioner.
all right.
I
Right.
already served.
All right.
our
I
oppositions
take more than 15 minutes.
The petitioners have concluded argument. This is what the order goes.
Yes.
Right. I'll hear the respondents added or whoever is there on the next day.
and my lord, with regard to the respondents being added, we are to file the oppositions, my lord, we have served, my lord.
If you have already added, it is all right, but no further
Yes, we
addition.
have added, my lord. My CAN was allowed, my lord, your lordship was directed to file the affidavits. We have served them, my lord. Let this
89.
89.
All right.
Well, let this
Serve.
part made part of the record, my lord.
এটা 89 এ হ্যাঁ ক্যান থাকুক
Can 14.
scan
15 and 16.
affidavit in opposition filed by the applicants in can 15 and 16. They must be as respondents
Yes,
in the writ
yes, yes,
petition. Number what is the name of your party?
Just
Has the amended cost title been circulated?
My lord, that is what I was going to say. Does not. It is required.
Yes.
Department may be directed
Yes.
for the
All right.
amended cost title. No, amend cost title amend হয়ে গেছে.
Leave granted to the learned advocate on record of the petitioner to circulate the amended cost title of the writ petition to all the parties.
My lord, only one thing, another liberty is required to be given, my lord. It is in your lordship's file, my lord. Unless there are two ways, my lord. I can take a picture and get a printout, or your lordships, if they allowed, department can give a photocopy of this.
আচ্ছা,
Otherwise, my lord.
ডিপার্টমেন্টে নামানো যাবে না এখন, এটা রেগুলার হিয়ারিং।
16.
আমাদের অফিসার তো
CAN
ফটোকপি করে দিতেই পারে।
শিল্পী চক্রবর্তী, my lord.
হতে গেলে এখন অনেক দেরি হয়ে যাবে। আচ্ছা, amended cost title of the writ petition be prepared by the ACO attached to this court upon proper seal and signature, and be handed over to the learned advocate representing the petitioners for circulation.
My lord.
এটার একটা ফটোকপি করবেন। তাহলে ডিপার্টমেন্টকে ডিরেকশন দিন। আচ্ছা, ডিপার্টমেন্টেই নামান।
CAN 15, it was Sheikh Dilawar Ali.
Department will prepare a photocopy of the amended cost. যেটা issue হয়েছিল সেটা ডিপার্টমেন্ট করবে upon proper seal and signature to circulate.
91. 89 এর পরে 90 টা আলাদা।
And affidavit in opposition file যে করছে সেটা দেখে নিয়ে বসে।
My lord, CAN 15 Sheikh Dilawar Ali.
নামটা দিয়ে বসে দিন না। Applicant in such and such. CAN 15.
CAN 15 Sheikh Dilawar Ali.
Sheikh Dilawar
And
All right, I'll take it up on the next day. The commission.
On by Monday, minute we'll file as
For the purpose of the amended cost title to be circulated, the file has to go down. So it will take some time. So I'll place it in the next week.
we'll circulate it by we'll serve it by Monday.
Today is 24th. The next Tuesday is a holiday.
Subject to your lordship, can I make a humble prayer? Item 92, the affidavits may be taken on record. We are added parties. 91.
91 addition of party, if it is allowed, then in that case, again, same thing, the department, it will go down for maybe, but then you're for taking your opposition on record, the amended cost title will be there. That can happen. You can circulate. যেহেতু কি আছে আমি উঠে গেলাম হ্যাঁ please check the server with the order.
Yes.
I've got a
Next week matter will fix.
all right.
On the next day.
Not on the second, my lord. Not on the second.